Be seated, please.
Thank you, Ricky. Chief Gilstrap, may I invoke a point of privilege before the proceedings begin?
The court recognizes Dean Brad Tobin. Please proceed.
Thank you, Chief. Welcome to the final round of the 2022 Top Gun competition. We have had a remarkable competition, just as we have had in the preceding 12 years. The other evening, Wednesday evening, we were delighted to have at dinner our 16 competitors, and I have noted to many of the friends and acquaintances that I've run into in the law center and beyond that I saw 16 lawyers at the podium, complete with confidence, poise, projection, and even the ability to engage in excellent, spontaneous humor. And so now we come to the point where the competitors, along with their wingmen, are here for the final round of the competition. I am assured that we are going to see outstanding advocacy today, as we have the last 3 days. I want to begin by acknowledging that the Top Gun competition is brought to us in a way of speaking. The sponsor is MG&M, which is a national law firm with offices in 13 cities across the nation. And I would like us all to acknowledge David Fisher, Kyle Stevens, who have been with us throughout the entire competition, and the managing partner of the firm, MG&M, John Manning, joined us for the middle 2 days of the competition. We so appreciate the firm's support of this outstanding advocacy contest. Thank you so much, David. Thank you, Kyle. Then also, we have, of course, the whole legion of folks who have put this together. But before I get to them, I want to introduce Chief Judge Rodney Gilstrap, Chief of the Eastern District of Texas. Judge Gilstrap, Chief Gilstrap, has been deeply involved in Baylor Law School. He, of course, is a Baylor judge, capital B, capital J. He has been deeply involved in the law school over many, many years, and I count him as a personal friend, and he is an esteemed member of our federal judiciary. Thank you so much for being with us today, Chief. Thank you. And then we have wonderful Baylor lawyers who will serve today as our scoring judges. I'm going to start here. First of all, Marilyn Brown, Jen Ruste, and Lynn Robbins. We have been so proud of each of you in your professional careers. You've each been out for a good period of time, not that long though, but they are all excellent trial lawyers. And one thing that has characterized our competition is that, of course, all of the presiding judges are, for lack of a better term, real judges, state and federal judges, and all of our scoring judges are real trial lawyers, most of them Baylor trial lawyers. A few others we allow into the guild, so to say, who don't come from Baylor Law School. But that is an aspect that makes this competition, one aspect that makes this competition, if not unique, certainly highly distinctive. A competition like this has a ton of moving parts, and I will say over the last 3.5 days, everything has flowed absolutely smoothly. Everybody has commented upon how all the moving parts have dovetailed together so easily. Well, but it's not easy. It's easy because it only looks easy. And we have several folks that I want to acknowledge who have been part of putting this all together. First of all, over here, Robert Little. Robert, raise your hand. Robert is the head honcho of Top Gun. Top Gun was originally the idea of my retired colleague, Jerry Powell, who directed our practice court program, of course, for so many years. I am sad he is retired, but of course, as the competitors saw from the very opening, He's in that video, the guy in the white suit, the Colonel Sanders looking guy who walked away into the sunset at the end of the competitor's entry video. Also, Stephen Rispoli, right alongside Robert. And then I'm going to read off several names here. And I have a piece of paper so I don't miss anybody. Our practice court team, of course, is Jim Wren, Liz Fraley, and Jeremy Consular. The IT team, wow, this is a competition where they have been running to and fro with all manner of matters to be addressed, and they have made it all happen so smoothly. I'm going to, with the IT team too, note that along with Robert, the last 2 years put on the Top Gun competition online on Zoom, which was a mighty accomplishment. Our team was the first law school, out of the gate in March of 2020, of course, right after the pandemic started, to begin planning not to put off Top Gun until the following year or whenever the pandemic ended, but to instead put it on, irrespective of the pandemic, in June of 2020, just 2 months later. And that's just illustrative of what the IT team has done. IT team, Rick Soul, Ricky Levetsky, and Chris Griesmer. And then Nick Texera, who's our photographer and also a wonderful graphic artist, has been deeply involved, as has Ed Nelson, whose work will kind of appear after the competition. He is our professional journalist. Kathy Sayre always deflects all credit. I'm not sure how to explain what she does. She does a little bit of everything, but her principal task in Top Gun and in everything she does is to worry. Everyone knows I always refer to Kathy as our worrier in chief. She makes sure that things happen. And then Chris Ruiz and Grant Jones. Chris and Grant are in the room here. They have been responsible for lots of the moving parts, especially getting the witnesses lined up and together and scheduled and the like. Chandler Dean is our practice court associate. Of course, Top Gun, in a sense, arises out of our larger practice court program and advocacy program. And Chandler, likewise, is deeply involved in all that we do here over these 3 days. Christine Bridges is behind the scenes in a lot of things that happen in the advocacy program. She is our career development officer, getting employment for our students. And the reason I want to mention Christine is we have multiple events happening at the law school here over the past few days. We have Top Gun. We also have had all of our Jaworski Fellows, which is our gathering of Baylor trial lawyers who come in throughout the year and help us in the practice court program in town to be honored at a dinner, which occurred last evening, and also, of course, to serve as judges, scoring judges in the competition. And then we have Stephanie Tang. Stephanie is new to our faculty, and I mentioned Stephanie here because she'll be a witness later, and I want her to feel welcome. She is literally brand new, just recently arrived in town to join the Baylor Law faculty. She is, in a sense, representative of just a whole lot of folks on the Baylor Law team that make these things happen. And I believe with that, Chief, I will retire. Thank you for the opportunity to thank those who have made the competition possible. And I believe that we're looking forward here for a few hours of spirited competition from our finalists. Thank you, Chief.
Thank you, Dean. All right, we're back on the record in this case. The case before the court is Bartlett versus College Cards, LLC. This is civil action TGCV 001-22. What says the plaintiff?
Your Honor, the plaintiff is ready to proceed. May we introduce ourselves?
Introduce your team.
Good afternoon. My name is Hayley Kairab. Today I'm joined by my co-counsel Cole Harper.
Good afternoon, Your Honor.
And together we represent Shea Bartlett.
Thank you, counsel. What says the defendant?
My apologies, Your Honor. The defense is also ready to proceed. May we also introduce ourselves?
Please do.
Good afternoon. My name is Regina Campbell. I'm joined in court today by my co-counsel.
Good afternoon, Your Honor.
Together, we represent the defendant, College Cards LLC. I'm joined in court today by our CEO, Ms. Seaborn.
And introduce your co-counsel's name for the record, please.
Enrico Trevisani, Your Honor.
Thank you. All right, counsel, before we get into other matters, I have the pretrial order before me, but let me inquire, are there matters related to pretrial that need to be taken up before we begin the case in chief?
Yes, Your Honor, we do have a few housekeeping matters as well as one substantive motion in limine whenever you're ready to hear from us.
You may proceed.
Your Honor, do we have permission to move about the well during statements and examinations?
Well, it depends on what you mean by move about the well. The typical rule is you may move from where you're standing. I don't want you further than an arm's length from counsel table.
Yes, Your Honor. And I understand that in this jurisdiction, traditionally, we have our home base at a lectern as well. I don't see a lectern in the room, but if you'd like, we could find one if that would be Your Honor's preference.
No, you may speak from counsel table and you may move as long as you're not further than an arm's length from counsel table. If for some reason you need to approach the witness or the bench or move beyond arm's length, then you need to ask for leave in advance.
Understood.
What else?
Your Honor, there are also a number of documents that have been pre-admitted in this case. We've been able to meet with defense counsel to discuss a number of them. Would you like a list of the documents that we've agreed to be pre-admitted, or would you like us to just let you know when those pre-admitted documents are being introduced?
Are there exhibits that are not pre-admitted or are they all pre-admitted?
There are a number that are, but there are also a number that have not been pre-admitted as well.
All right. In that regard, if it's a pre-admitted exhibit, then either side may use it without a proffer or a prior introduction. If we get to the point, when we get to the point where exhibits that are not pre-admitted are used, then you need to make an offer and I'll hear a response if there's any objection.
Understood, Your Honor. Also, on that note, do we have Your Honor's permission to use a few pre-admitted exhibits and some demonstrative aids during opening statement to put them on the screen?
Yes, you do.
Your Honor, the plaintiff invokes Rule 615, calling for the sequestration of all non-essential witnesses or party representatives. Today, we have our party representative, Shea Bartlett. We also do intend on calling an expert witness, Jamie Craig. We ask that all other non-essential witnesses be excused.
All right. The rule has been invoked. Therefore, unless you're a corporate representative, you're directed to remain outside the courtroom until you're called to the witness stand.
Yes, Your Honor. May we assume that all sidebars are constructive?
I think that's probably a good choice given our circumstances. Otherwise, I'd have you come to the bench, but we'll do it constructively in this case.
Yes, Your Honor. That's it for housekeeping from us. We also do have one substantive motion if you'd like to hear that at this time.
Let me see if defendants have anything in the way of housekeeping.
Yes, Your Honor, just one thing. There are a couple of exhibits that opposing counsel has told us they have no objections to and they have no issues with us using during opening statements, but they have not yet been pre-admitted. We ask permission to use those particular exhibits during our opening statement, given that we have a good faith basis that they're going to come in during the trial.
All right. Can you identify those exhibits for the court?
I can, Your Honor. There are 3 of them, or excuse me, there are 6 of them. Exhibits 1, 2, and 3, and exhibits 35, 36, and my apologies, Your Honor. I'm just going to read it from my co-counsel's computer here. Exhibit 60, Exhibit 1, Exhibit 2, Exhibit 37, Exhibit 36, and Exhibit 35.
All right. Does plaintiff have any objection to the pre-admission of these, given the representation made by defense counsel that there haven't been prior objections raised?
No, Your Honor, there are no objections. I would just like to clarify, at least according to our records per the pretrial order, the only one of those documents that has not actually been pre-admitted is Exhibit 60, and we have no objection to that being used during opening statements.
All right. Well, whether formally pre-admitted or not, exhibits 1, 2, 35, 36, 37, and 60 are considered pre-admitted. Other housekeeping matters from defendant?
None, Your Honor. We're ready to move on to motions.
All right. Let's hear your motion first, please.
Yes, Your Honor. Our first motion involves evidence of a prior acquittal. This claim is a civil claim where Shea Bartlett, an investor in the defendant's business, College Cards LLC, is alleging civil fraud. Prior to this claim being brought, The CEO of College Cards LLC was federally prosecuted and acquitted. We'd moved to exclude any mention of that acquittal as being unfairly prejudicial under Federal Rule of Evidence 403.
This is in the nature of a motion to eliminate.
Yes, Your Honor.
What's defendant's response?
Your Honor, our response is twofold. If opposing counsel agrees that they're not going to call an FBI agent who's going to discuss a criminal investigation into Ms. Seaborn, then we'll agree that we won't bring up the result of that investigation, which was an acquittal. But if they're going to call an FBI expert to the stand who is going to say that there was a criminal investigation and then detail that criminal investigation, we ask that we do be allowed to talk about the results of that investigation, which is that there was an acquittal. Essentially, Your Honor, we don't think it's fair for opposing counsel to be able to ask their FBI agent to talk about the existence of a criminal investigation without us being able to talk about the result of that investigation.
All right. I'm going to grant the plaintiff's motion to eliminate and exclude any reference to the prosecution and acquittal of defendant's representative. However, if the plaintiff elects to call an expert witness or any witness that goes into and raises that issue, then the court will consider the doors open and the court will grant leave to the defendant to go into the facts regarding the acquittal.
Yes, Your Honor.
All right. Other matters of pretrial nature that we need to take up.
That's it from the plaintiff, Your Honor. We're ready to move into opening statements.
Defendant?
Defense is ready.
All right. Then we'll proceed with opening statements. The court will hear from the plaintiff first.
Yes, Your Honor. May it please the court,
Please proceed.
opposing counsel, members of the jury. It was a fake product, but it was real fraud. In March of 2020, everyone was starting to figure out their pandemic thing. Some people were baking bread, some were going on walks, some people were exhausting every TV and movie option available on Netflix. But the CEO of this defendant corporation, Kirby Seaborn, had a different idea. An idea for how to get rich quick. In the world of cryptocurrency, it's called a rug pull. It's actually pretty simple. You come up with an idea for a fake product. You pitch that faked product to investors. You get investors excited about the product. You get them to believe that the product will be what you promised. You get them to invest money. You take that money, you pretend to make the product, and then you quit before you ever have the product that you promised. Today, what the evidence will show is that is exactly what this defendant corporation did. They made a promise to investors to produce this product.
And that's a three again by Butler.
You see, the defendant corporation made a promise that they had a product that could revolutionize the world of digital trading cards. No more were just static images with a picture. This defendant corporation promised a product that had video, highlights from your favorite players' greatest moments. What you'll see today is that product that you just saw never belonged to the defendant corporation. The art was never theirs. The product that they promised was never real. It was a fake product, but it was real fraud. So let's take a minute and talk about the members of the team that were making this product. At the top of the food chain, you've got the CEO of the corporation, Kirby Seaborn. Kirby Seaborn was the one with the idea to create this fake product. As a part of Kirby Seaborn's team, she had 3 heads of department. She had Casey Lyman, the head of finance, the chief financial officer. She had Donna Moss, the head of marketing and outreach, the person who would be fulfilling the promise of getting athletes from all across the world to be on these cards. And then there was Charlie Young, the head of art, the person who was supposed to be making the cards that you just saw. Then at the bottom of the food chain, there was Avery Ziegler, a member of the art team that was also supposed to be working on that product. This team never created that product. Why? Their CEO stood in their way. In response, when the product they created failed, what you'll learn is what came next. You see, the CEO of this company didn't head back to the drawing board to fix the product. The CEO didn't figure out what to do with her team to make changes to improve. What you'll learn is that when the product failed, Charlie Young got fired. Donna Moss got fired. Casey Lyman got fired, leaving 2 people, Kirby Seaborn and her best friend, Avery Ziegler, left with a company, no product, and $9 million. It was a fake product, but it was real fraud. That's why we've brought a claim of fraud against College Cards LLC. And with that claim comes a burden to prove our claim by a preponderance of the evidence. To do that, we've got to show you 4 things. We've got to show you that College Cards LLC made a material misrepresentation, that they made that material misrepresentation with knowledge of its falsity, or that it was made recklessly without any knowledge of the truth as a positive assertion, that such representation was made with the intention that it should be acted on by Shea Bartlett, the plaintiff, and that Shea Bartlett, the plaintiff, justifiably relied on that material representation and that she suffered harm. We'll meet our burden because today we will show you the entire life cycle of this defendant corporation scheme. You're going to meet Jamie Craig. You see, she looked into the actual scheme that this corporation was running, the fraud, the fake product. Ms. Craig will talk to you about how a rug pull is pulled off. You make a promise. You raise the money. You break the promise. You keep the money. She'll tell you that those components line up with exactly what this defendant corporation did. You'll meet Casey Lyman, the head of finance that we talked about earlier. Mr. Lyman's going to talk to you about request after request for more funding to make a product that would work, about problem after problem that their CEO ignored. And finally, you'll get to meet Shea Bartlett. Shea Bartlett is one of the people who believed in the defendant corporation's lies. Shea Bartlett invested money in this company because she believed in their product. She believed in their promises. She believed in the vision. Ms. Bartlett's going to talk to you about what it was like to be blindsided by a business that never made the product they promised. It was a fake product, but it was real fraud. And that's why, at the end of today's trial, we're going to ask that you find the defendant liable. Thank you.
Defendant may now proceed with its opening statement.
Yes, Your Honor. The plaintiff got everything. that she was promised. It's April 5th, 2021. Inside the Lucas Oil Stadium in Indianapolis. Green and gold confetti rains down on a sea of Baylor Bears. And the crowd, they're chanting, "Sick 'em Bears, sick 'em Bears." On the basketball court, the men's Baylor basketball team is jumping up and down. One of their players, Jared Butler, is holding up a championship MVP trophy. And folks, in that moment, if Baylor fans across the country wanted to celebrate this historic championship, if they wanted a piece in Baylor's success, there was only one place where they could get a Jared Butler trading card. One place where they could get a trading card for any of the college athletes they just watched win. This woman's company, College Cards LLC. This is Kirby Seaborn. She's 21 years old. And today, the evidence will show that this woman is no fraud. The evidence will show that she's young. She's hungry. She's a businesswoman who came up with a great idea. You're going to learn that 2 years ago, this woman was a junior at Baylor College when she had an idea. For the first time, college players were able to sell their names, their images, their likenesses to marketing. And so Ms. Seaborn thought, this would be a pretty good business idea. College trading cards. Within 1 month, investors were lining up. Within 4 months, this woman secured licensing agreements from championship Baylor athletes. And within 5 months, she gave all of those investors everything she promised. She gave them the artwork she promised. She gave them the Baylor Bears she promised. And so when the plaintiff tells you that she didn't give them the video that was promised, you're going to learn she never promised a video. You're going to learn that the plaintiff got everything that she was promised. Now, the plaintiff in this case, they've sued Ms. Seaborn's company, College Cards, for something called fraud. But they've got a burden. They have to prove to you, by a preponderance of the evidence, that this woman stole people's money in order to give them a product she didn't have. They will fail to meet their burden. They will fail to show you that she made any false representations. They will fail to show you that she intended to defraud anyone. And they will fail to meet that burden because of 3 simple facts. 1, the plaintiff got the artwork that she was promised. 2, the plaintiff got the athletes that she was promised. And 3, the reason that the plaintiff is upset is because she expected something that College Cards never promised. So let's take those one at a time. Starting with the first one. The plaintiff got the artwork that she was promised. This is what College Cards promised the plaintiff. They promised her that she was going to get this design, this aesthetic. The green and gold Baylor Bears, the national championship logo, the colors, the aesthetics, the piece of art. The evidence will show that this is what she got. The evidence will show that your eyes aren't deceiving you here, folks. It's exactly the same. You're going to learn that College Cards gave the plaintiff the same aesthetics. The same green and gold, the same border, the same logo, the same artwork. The artwork that she was promised. Fact number 2. The plaintiff got the athletes that she was promised. During their opening statement, plaintiff's counsel told you that, College Cards was engaged in some sort of scam. They said that they were selling a, quote, fake product. Well, what you're actually going to learn that there was no scam. There was no scheme. She had a business plan. A plan to sell people a product, a real product that they wanted, and that investors were going to make a lot of money off of. And so I want to make sure we all understand what exactly it was that she was selling, what it was that she was promising. So we all know what trading cards are. They're, small cardboard, has athletes on them, pictures on the front, stats on the back. What had never been invented before Ms. Seaborn is trading cards for college athletes. That was her big idea. That's what she came up with. And members of the jury, the evidence is going to show that that is what she gave her investors. You see, the plaintiff just told you that the College Cards didn't spend the money that they got to get the product that investors paid for. What you're actually going to learn is that College Cards spent $250,000 getting the athletes, securing the licensing agreements so that they could get those cards we just showed you. The evidence will show that they were successful in getting those athletes. The evidence will show that the plaintiff got the athletes that she was promised. Fact number 3. The reason that the plaintiff is upset is because she was expecting something that we never promised. During their opening statement, the plaintiff said that, their client, she didn't get a video, and she was expecting a video. But what the evidence is going to show is that College Cards never promised a video. You're going to see a tweet that College Cards put out onto their public account, put out for their investors, put out for the plaintiff. In that tweet, a video was listed, but at the top of that tweet, Ms. Seaborn wrote, "This is what we envisioned." In other words, the evidence will show that they wanted to give their investors a video, that they hoped to create a video, but they never promised that they would get the video. And so, members of the jury, the evidence is going to show the plaintiff was expecting something that she was never told she would actually get. Now, during their opening statement, the plaintiff said they were going to call a witness who was going to explain to you that there was this big plan, this big scheme to defraud, that this woman was trying to take money from people. That witness's name was someone named Casey Lyman. What the evidence will show is that Casey Lyman actually used to work for this company. And that while Casey Lyman was working for the company, they didn't think it was fraud. For months, they were managing the finances for this company, and they didn't think it was fraud. But then you're going to hear that Casey Lyman got fired. And it was only after Casey Lyman got fired that she started claiming fraud. Plaintiff counsel also told you during their opening statement that the plaintiff lost out on some money. Members of the jury, we're not disputing that. We agree. She lost money. But the evidence will show that that's just how it works in a market. When you invest money into a project, sometimes you win, you succeed, you return on your investment, maybe you make some more money. But the evidence will show that sometimes those investments fail. The evidence will show that failure is not fraud. Facts, members of the jury. They're stubborn things. They can't be changed. They can't be avoided. Today, it will be undisputed fact that the plaintiff got the artwork. Fact that the plaintiff's artwork had the athletes. Fact that the video the plaintiff is upset about was never promised. At the end of this trial, we're going to ask that you find College Cards LLC not liable because the plaintiff got everything that she was promised. Thank you.
All right, counsel, we'll proceed with the plaintiff's case in chief. Plaintiff, call your first witness.
Yes, Your Honor. First, the plaintiff calls Kirby Seaborn.
All right. Ms. Seaborn, if you'll take the witness stand. For the record, all the witnesses have previously been sworn.
Yes, Your Honor. And considering that we will be calling Ms. Seaborn as an adverse witness, we do ask for permission to lead under Federal Rule of Evidence 611.
That's quite acceptable. The court recognizes this as an adverse witness. All right, counsel, proceed with the direct examination.
Yes, Your Honor. Ms. Seaborn, you're the person that created College Cards LLC.
That's correct. I did.
You are the CEO.
I am.
You're responsible for what the company does.
That's correct.
You're responsible for how the company spends.
Yes.
All the decisions about all of the funding were yours.
Yep. I made all of the higher up decisions.
Now, I want to be clear. Let's talk about what you told investors about a product. Your Honor, permission to display what's been previously admitted as Exhibit 60.
If it's previously been pre-admitted, counsel, you don't have to have leave of court. Use it as you choose.
Understood. Ms. Seaborn, can you see that on your screen?
I can.
This is a tweet that you put out in July of 2020.
Yes, right when we were first thinking of the idea.
But in this tweet, you don't just post a photo, right?
Yes, that's correct.
That's a link to a video.
It is. It's showing what we envisioned. I'm a big dreamer and I wanted to do something big.
That's right. In this tweet, you said this is what you envisioned for the product.
Yep, that's exactly what I said.
I want to be clear about something. The video that you linked in this tweet did not belong to you. Did it?
The video in the tweet?
You did not make the video that you posted in this tweet, did you?
Oh, as far as the artwork, correct. Yes.
The artwork belonged to someone else.
Yes, that's true. This was what we envisioned.
The person that made this artwork was not employed by you.
That's correct.
You didn't ask for permission before you used the artwork that you said was your vision.
No, I didn't think I needed to.
When you made this tweet on July 5th of 2020, College Cards LLC had made zero artwork of its own.
Yes, that's correct.
Now, this tweet says that this is a vision. But let's talk about what you said 10 minutes later. Your Honor, displaying what's been previously admitted as Exhibit 13. This is another tweet of yours. Yes?
Yes, that's mine.
From the same day you posted about your vision.
Yes.
It's about 10 minutes later that you made this tweet.
Looks like about that, yeah.
But this time, you don't talk about a vision. Do you?
I say that this is what our cards are going to look like.
Well, let's be clear, Ms. Seaborn. What you say is you've seen our artwork.
Yes, as was shown in the tweet 10 minutes earlier.
This doesn't say this is what our artwork will look like once we've got a staff to make it, does it?
Not in those exact words, no.
You say that the artwork is yours.
Yes.
You still didn't have any artwork of your own.
No, not at that time.
You lied.
You could read it that way, but I was just showing what we hoped that the cards would look like.
Ms. Seaborn, yes or no? You lied.
This is the artwork that we hope to use.
Ms. Seaborn, I asked you a yes or no question.
Like I
You lied in
said,
this
yes,
tweet.
you could interpret that way.
Counsel, if you believe the witness is non-responsive, raise it with the court will address it.
Yes, Your Honor. Mr. Harper, we can take down this tweet. At the time you made these tweets, your company didn't have any money yet, right?
Not at the time of these tweets, no.
You needed to make a pitch to investors.
Correct.
You made a pitch in August.
Yes, I did.
You still didn't have any artwork of your own.
Not yet, no. That's what we were trying to get with the investors.
You showed that video that didn't belong to you.
The artwork in the video, yes.
You got $10 million.
I did. It was a really big success.
Now, you had 4 other people on your staff.
At the time, yes.
So 5 of you in total with a $10 million budget.
Correct.
Let's talk about what you did with that budget. You spent $250,000 on art.
Yes, I did.
You spent $500,000 on athlete outreach.
$250,000 on athlete outreach, actually.
Excuse me, yes, $250,000 on athlete outreach.
Correct.
You never increased funding for those departments.
No, I was never requested.
You never spent a cent more than those 2 amounts that we just talked about.
No.
To make your product, you're telling us that you spent 5% of your total budget
Yes, that's correct.
and then you released the product.
Yes.
You haven't touched that product since.
Not since we've been embroiled in this lawsuit.
So that's a no.
That's a no, yes.
Your Honor, we pass the witness.
Cross-examination by the defendant.
Yes, Your Honor.
And counsel, given that this is your representative, you're not permitted to lead on cross-examination.
Of course, Your Honor. Understood. May
Please
I-
proceed.
Yes, Your Honor. Ma'am, I know you were already just asked a lot of questions, but I want to give the jury the opportunity to meet you. Can you introduce yourself?
Of course. My name is Kirby Seaborn.
How old are you?
I'm 22.
Are you currently in college?
No, I'm not. I dropped out so that I could run my company full time.
You said you dropped out to run a company. What's the name of your company?
The name of the company is College Cards.
Ma'am, I want to make something perfectly clear. When you dropped out of college to start your own company, were you planning to defraud anyone?
No, of course not.
Did you intend to scheme people?
No, I would never do that.
Let's take a step back and talk about what it was that your company was going to promise investors. So, ma'am, just to clarify, what is it that you were selling at College Cards?
We wanted to do something that no one had ever done before. College athlete trading cards. That was the dream that we had.
So, what made college athlete trading cards special?
Well, before the new legislation, college athletes weren't allowed to have their own trading cards with their name and their images on them, but that changed. And so we were going to be the first company ever that would have college athlete trading cards.
Okay, so you come up with this idea to sell these college athlete trading cards. Did you have any money yet?
Not yet, no. Like I said, I dropped out of college.
So how'd you plan to raise some money?
Well, since the idea was a trading card that we were going to do online, we had to get investors. And so I used some online social media forums to draw in investors and raise money for what we hope to do.
I want to take a look at one of your tweets that you were just shown by opposing counsel. Your Honor, for the record, I'm displaying Exhibit 60. Mr. Trevisani, can we get Exhibit 60 without the call out just yet? Right, ma'am. So just to contextualize this a little bit, is this one of the tweets that you put out to your investors?
Yes, this is one of those tweets.
What did you link here in this tweet?
I linked a video of what we hoped that the trading cards would look like.
Ma'am, in this tweet, did you tell investors you will get this video?
No, like I said a moment ago, I was a big dreamer. I wanted to make something big, and so this is what I hoped that we would be able to make, what we envisioned to make.
And so did you ever tell an investor that you will give them a video?
No, never.
Can we actually put that tweet back up, Mr. Trevisani? So, ma'am, I actually want to clarify what it is that you did promise your investors. In this tweet, I see that there's sort of a trading card and there's a border around this trading card. Did you promise investors this is what the art was going to look like?
I did. You can see the background with the yellow spots and then the green border of the card with the athletes kind of jumping out of the frame. We thought that was really exciting, as well as the national championship logo, the athlete number, and their name at the bottom in that font.
I also see that there's a man holding up a basketball in this photo. Who is that? Or in this video, rather. Who is that?
Davion Mitchell, what a player. He's one of the athletes that we got to put on our cards.
So, ma'am, when you posted this tweet, were you promising investors that you were going to get athletes?
Yes.
Let's talk about whether you gave your investors everything that you promised your investors. You mentioned that you were able to get a licensing agreement for this big player, Davion Mitchell. Can you explain how you were able to do that?
Well, like I mentioned, the new legislation allowed college athletes for the first time to start selling their name and their likeness, their photos. So we approached them and we just got them to agree to allow us to use their photo and their name in our trading cards.
You say you got them to agree, ma'am. I want to be perfectly clear. Did you spend money to recruit athletes?
I did. We spent a total of $250,000 for the first 3 trading cards that we developed.
And is that the money that you got from the investors?
Yes, that is the same money.
So, ma'am, would it be fair to say that you spent the money you got from investors to give them what you promised?
Yes, that's exactly what we did.
I want to jump to one more thing that opposing counsel asked you during her questioning. Ma'am, do you remember when she asked you a kind of a direct question, whether or not you lied in a tweet?
I do.
And your answer was, you could see it that way, right? Or, excuse me, do you remember your answer to that question?
My answer was that she could interpret it that way, if that's how she wanted to read it, but that's not what I wrote.
So, ma'am, I want to be clear. Did you intend to misrepresent anything to your investors?
No, of course not. I was just saying that this is the artwork that we hope to produce when we eventually got the trading cards ready.
Thank you, Ms. Seaborn. Your Honor, we have no further questions.
Pass the witness. Defense counsel, do you pass the
Oh,
witness?
my apologies, Your Honor. We passed the witness.
Is there a redirect from the plaintiff?
There is no redirect, Your Honor. We ask that Ms. Seaborn be able to step down.
All right, you may return to counsel table, Ms. Seaborn. Plaintiff, call your next witness.
Yes, Your Honor. At this time, the plaintiff calls Jamie Craig.
All right. Someone needs to bring Ms. Craig into the courtroom. Please take the witness stand, Ms. Craig. You've previously been sworn. Plaintiff, you may proceed with direct examination.
Yes, Your Honor. Good afternoon.
Good afternoon.
Could you please introduce yourself to the members of the jury?
Sure. My name is Jamie Craig, Cregg.
What do you do for a living?
I am currently a consultant for law firms and other companies on areas of blockchain, digital currency, and cryptocurrency.
And what sort of work were you doing before you got into consulting?
Sure. I was an agent for the Federal Bureau of Investigations. I had two primary roles there. So first, I was a member of their virtual asset exploitation unit. And second, I was a member of the National Cryptocurrency Enforcement Team.
How long were you with the FBI?
A few years after completing my master's at Northwestern in computer science.
Now, how did you become involved in this case?
Sure. So I first received a tip from Casey Lyman, who was the chief financial officer of College Cards, that something was going wrong with the company.
Did you get this tip while you were still working with the FBI?
I did.
What did you do with that tip once you got it?
I looked further into additional documents that Ms. Lyman was able to provide to me, which included emails, tweets from Kirby Seaborn, the CEO of College Cards, and financial records as well.
Were the materials that you reviewed during the course of your FBI investigation sufficient?
Yes,
Did you investigate this case based on that tip?
I did, yes.
Did you investigate this case in accordance with standards you've been taught at the FBI?
I did, yes. We did eventually obtain, through the information that Mr. Lyman provided us, we were able to secure a warrant to obtain additional documentation through looking at College Cards, computers, cell phones, and additional information within their company.
During the course of your investigation and your review of these materials, were you able to come to a conclusion, without going into the details just yet, about whether there was fraud involved in this case?
I was, yes.
Your Honor, at this time, we move to tender Ms. Craig as an expert in digital investing.
Is there objection?
Not to that tender, Your Honor.
All right. The court will recognize this witness as an expert in that designated field. Please proceed.
Ms. Craig, I want to talk to you a little bit about the world of cryptocurrency in general. When you're investigating fraud, are there different types of schemes that you might look for?
Yes, there are.
In this case, which sort of scheme did you think you were dealing with?
We were sure that we were dealing with a rug pull.
Could you explain to us what a rug pull scheme is?
Sure. A rug pull is a type of fraud that's committed by nifty creators. Essentially, the nifty creator will lure investors in with a promise, a particular NFT. So, for example, a type of digital art in this case. Once the investors are lured in, the nifty creator raises money for the nifty project and effectively pulls the rug out from under those investors, hence the name rug pull, and they break their promise. They either don't deliver and they ghost the investors and don't deliver any NFTs, or they deliver an NFT that is not in line with what the promise characteristics were for that NFT, and they keep all of the money that was raised from the investors.
Now, an NFT, what is that?
Sure. So an NFT is what we refer to in this area as a nifty or a non-fungible token. Effectively, it's a service that contains some metadata that's on a blockchain. Now, that's a lot of technical words, so I'm happy to break that down further.
Well, did this defendant's business involve an NFT?
Yes.
And what does that mean?
Sure. So an NFT in this particular case was a form of digital artwork. So say a very common NFT is the crypto kitty, which is exactly what it sounds like. It's a digital picture of a kitty. And it contains snippets of code that are metadata, just like you have in a picture or a Word document. And the metadata really defines the characteristics of the NFT. So again, going back to my example of the crypto kitty, the metadata could describe whether that kitty was wearing a hat, the color of its fur, the shape of its eyes, any of those physical characteristics that will ultimately show up in that digital piece of artwork, which is the NFT.
I'd like to talk about what it takes to actually investigate a suspected rug pull. Are there common components to this sort of scheme that you look for in an investigation like this?
Sure. Investigating a rug pull, you're looking at two primary things. There's the intent to actually commit the fraud, and then second, that they had actually kept the money.
Okay, so let's start with that first part. During the course of your investigation, did you find any evidence that this defending corporation made promises to their investors about a product?
Yes.
Could you provide some more details about what that promise was?
Sure. So in this case, College Cards, just like in a common rug pull situation, to just back up a second, typically in a rug pull, what happens is that the NFT creator will create a tweet or social media, Discord chat, or what have you. Think about when you have a common sale that a store is providing. They advertise the sale, right? So very similarly, the NFT creator advertises this new nifty project that they have. So here, College Cards advertise that nifty project by showing these curated artwork with the animation on it. Then once that is established, that's kind of the promise, the investors can sign up for what's called a whitelist. Think of this as the VIP list, the first in line to get the NFT. So we have the whitelist that people sign up for, and that whitelist gives you access to a private sale. And it guarantees you the ability to obtain what's called a mint pass. Now, a mint pass, again, think of it as kind of a voucher, again, like you do in a sale situation. You obtain this voucher, and that guarantees that you're going to get an NFT, but it doesn't necessarily it does not show you what that NFT is going to look like. It just is kind of a representation of it. Ultimately, the NFT, the mint pass can be converted once the NFT is released to digital artwork that looks like, hopefully, a curated piece of art. In this situation, with College Cards.
Objection, Your Honor. At this point, the witness is launched into a narrative.
Sustained. This is an expert witness, but you're going to have to examine her discreetly. She's not here to give a lecture.
Yes, Your Honor. Ms. Craig, I'm going to ask you a few more specific questions, and then we can break down that answer. Let's start with what a mint pass is. Could you mention that a mint pass is like a voucher? How does that work?
Sure. So a mint pass you purchase for a couple of Ethereum, which is the blockchain that the NFT is on. And again, this is kind of like a voucher. It guarantees you the ability to obtain an NFT once it's actually released.
Now, were there any investors that purchased mint passes for the defendant corporation?
Yes, there were.
How many investors?
They were able to raise about $10 million, which is about 3,000 Ethereum or ETH, which is the currency that's used to purchase the mint passes and the NFTs eventually. So in total, it depends on how many mint passes they ultimately purchase, but they were able to sell approximately they were able to sell a certain amount of mint passes to get to that $10 million at 3 Ethereum a piece, which is about $10,000. So about 1,000 total mint passes were distributed.
Now, you mentioned that when you buy a mint pass, there isn't actually a product yet. When do you actually get the product?
Sure. So it could be a few months after the mint pass is distributed at this private sale, but then the mint passes are held in what's called a digital wallet. Think of this as your personal physical wallet, right? You have a digital wallet online that you can log into, and the digital wallet just has your mint pass. One day you get an announcement, usually via a chat platform or social media from the nifty creator, that says, okay, we're ready to release the NFT, go into your digital wallets. You press the refresh button, and that mint pass, that is just a kind of representation of what the NFT will ultimately be, is converted into that digital artwork that you bought.
So once the product enters an investor's what you call digital wallet, does that product belong to the developer or the investor now?
It now belongs to the investor.
So let's talk about how that logistically works then. Once a product is released or once the product is put into an investor's digital wallet, Can the developer now continue to change that product?
No, they cannot.
Can any more money be used to improve that product?
Not the mint passes or the NFTs that were already released, no.
Now, in this case, when was the product actually placed into the digital wallet of this defendant company's investors?
December of 2020.
So after December of 2020, would it be possible to spend any more investor dollars improving that product?
No.
Are you aware of how much money the defendant corporation still had in its bank account at the time they released the product to their investors' digital wallets?
Approximately $9 million, if I'm remembering correctly.
Thank you, Ms. Craig. Your Honor, we pass the witness.
Cross-examination.
Yes, Your Honor.
Counsel, we're going to have a constructive bench conference at this point. Based on the limiting motion that was raised earlier, the court's persuaded that plaintiff has developed enough of the FBI investigation that it's implicitly applied to this defendant, and I'm going to grant leave to the defendant to explore any acquittal or other information that would rebut the inferences that have been raised by the direct examination.
Yes, Your
All right.
Honor.
Understood.
That concludes the constructive bench conference. Proceed with your direct examination.
Yes, Your Honor. You just told this jury that you conducted a criminal investigation, right?
That's correct.
I want to talk about the results of your investigation. Ma'am, you know that at one point this woman was put on trial for fraud, right?
Yes,
You know the result of that trial
I do.
for fraud.
For
This
wire
woman, I'm sorry?
For criminal wire fraud, yes.
Okay, so for criminal fraud, Ms. Seaborn was found not guilty, right?
That's correct.
I want to talk a little bit more about the thoroughness of your investigation. Now, we can both agree that when you're investigating someone, it's important to be thorough.
That's correct.
It's important to look into all the important evidence.
Yes.
Because if you're not thorough, you can make mistakes, right?
Sure.
Now, in your investigation, you found that College Cards ended up getting money from 1,000 people, right?
I didn't say that. I said that there were 1,000 mint passes distributed. Each investor could have purchased multiple mint passes depending on what they were looking for.
Understood. So 1,000 mint passes were sold.
Correct.
Ma'am, do you know how many people bought those mint passes?
I do not.
Ma'am, the reason you don't know that is because you never tried to figure it out, right?
I didn't think it was relevant for the purposes of figuring out whether a promise was made and whether that promise was broken.
Hold on, agent. It's your testimony that you didn't think it was relevant to talk to the investors?
I did talk to, again, we looked at the final product, and the final product did not match the promised NFT that was promised to all the investors in that pool.
Ms. Craig, that wasn't my question. Is it your testimony that it wasn't relevant for you to figure out how many investors there were?
I didn't think it was, no.
You understand that part of fraud is what was lost or what investors lost, right?
That's correct, but you are able to see what the College Cards NFTs are selling for, and you're able to look at all of those again on the OpenSea marketplace.
Ma'am, that was not my question.
Just a moment, counsel. Ms. Craig, you need to confine your answers to the questions asked.
Okay.
Plaintiff's counsel is going to get a chance to redirect and address anything she thinks needs to be recovered, but you need to limit your answers to the questions that are asked on cross-examination.
I apologize, Your Honor.
Let's proceed.
So you know that one of the elements in fraud is demonstrating that investors lost money, right?
Correct.
In your investigation, you didn't talk to any investors, did you?
I did not.
So, ma'am, you didn't ask any investors if they lost any money.
No.
You're testifying today on behalf of the plaintiff, right?
That's correct.
You've never met the plaintiff.
Not before. I I've talked to the plaintiff, but not as part of the criminal investigation.
It's your testimony that you've talked to the plaintiff before?
I have talked to plaintiff's counsel before.
So let me redirect you back to my question. You understand the plaintiff in this case is this woman sitting at this table, right?
I do.
You've never met this woman before,
No.
right? You've never talked to this woman before.
No.
And when you were doing your investigation, you never asked her about her losses, right?
No.
I want to talk about whether this case did in fact involve any fraud. You know that there was more than one investor who bought mint passes from College Cards, right?
I do.
There was more than one investor, but only one investor is suing, right?
That's my understanding, yes.
Out of the 1,000 mint passes that were sold, only one person is claiming civil fraud. Objection, Your Honor, to lack of personal knowledge.
Overruled. If she knows, she can answer. If she doesn't know, she can say she doesn't know.
I don't know.
You don't know how many people are suing?
I don't know how many people are suing at this
And you were supposed to be investigating this company, right?
That's correct, but I don't know if there's anyone who's planning to sue or anyone who's currently suing. I haven't checked the civil docket.
Sure, so you don't know who's suing the company that you were supposed to be investigating?
Correct.
I want to talk about how the market works. We can both agree that the plaintiff invested in the NFT market, right?
Yes.
We can both agree that markets, they're unpredictable, right?
Yes.
Sometimes people invest in a market and they succeed. The market succeeds, or excuse me, the company succeeds.
Yes.
They make more money, the investors.
Yes.
But sometimes people invest in the company and the company fails, right?
That's correct.
Sometimes people invest in a company and they actually end up losing their money.
Yes.
But we can both agree, ma'am, that just because a company fails doesn't mean that company committed fraud, right?
In other circumstances, certainly.
Thank you. Nothing further.
Is there redirect?
Yes, Your Honor.
Please proceed.
Ms. Craig, are you able to make a determination about how the value of a product increases or decreases without actually talking to the investors that own them?
I am, yes.
Were you able to do that in this case?
Yes.
Now, when evaluating whether this case involved fraud, did you consider the possibility that it was just a failure?
I did, yes, but that's not what the document supported.
Thank you, Your Honor. We passed the witness, and barring any recross, we ask that Ms. Craig be excused.
Well, let's see if the defendant has additional cross-examination.
None, Your Honor.
All right, then you may step down, Ms. Craig.
Thank you.
And you're also excused. Plaintiff, call your next witness.
Your Honor, at this time, the plaintiff calls Casey Lyman.
Let's bring in Ms. Lyman, please. You'll please take the witness stand. You've previously been sworn. Counsel, proceed with your direct examination.
Good afternoon.
Hello,
Could you please introduce yourself to the members of the jury?
I'm Casey Lyman.
What do you do for a living?
I'm a student.
Have you ever been involved with a company called College Cards LLC?
I unfortunately was, yes.
Let me interrupt a minute. Mr. Lyman, take your cap off in the United States District Court. Thank you. Proceed, counsel.
Yes, Your Honor. Mr. Lyman, let's talk about how you became involved in College Cards.
Well, I used to hang around with Kirby, and we sort of started college together, got to know each other, and we're always kind of coming up with ideas of things to do, and we just sort of came up with the idea right before the pandemic started.
Was Kirby Seaborn a friend of yours?
Oh, yeah. I mean, from the beginning of college, I didn't know him before college, but we ended up in a class together in a study group and kind of hit it off and kind of started going down the same path together with things we liked. We liked college sports. We liked video games. We liked going out to party. I mean, doesn't every 18-year-old?
So then let's talk about the business itself. What was the product that you and Kirby Seaborn decided to make?
Basically, an electronic version of a baseball card. I mean, essentially, everybody's familiar with sports cards, and so we decided to take advantage of technology and sort of make an electronic card rather than kind of a paper card.
Now, aside from your product being digital, was there anything else that would set your product apart from just a standard physical sports trading card?
Yeah, and that's the advantage of doing the sort of the digitizing is ours would have sort of video. You would see not just a static image, you would see the person performing something. In our case, it was originally going to be basketball, playing basketball. And you could also then work graphics into that sort of composite. And so it would have sort of multi-dimensions to it rather than just looking at the card you're holding in your hand.
And the athletes that were going to be on this card, on these cards, were they all going to be just from Baylor?
No, because that wouldn't have been had the sort of nationwide appeal that we were hoping for. And so the idea was that we would get this thing going and talk different athletes from all of the big schools, at least the top schools in basketball anyway, because the new legislation that had been sort of coming down the pike with the ability of college students now to get paid for letting their image and stuff be used. And so it was kind of a whole sort of can of worms that had just opened up that had never been available before because you couldn't pay college students, athletes couldn't get money.
What was your role in College Cards LLC?
I was the chief financial officer.
Do you have any sort of background in graphic design?
No.
What about a background in marketing?
No, I can barely turn a computer on.
So was it ever your job to work on the product that was being created by the company?
No, I had nothing, absolutely nothing whatsoever to do with the product.
Despite that, were you familiar with how the product was actually progressing leading up to the day it was released?
There were some indications from a couple of the other people that he had hired to fulfill our promises to the investors that things might not be going the way they had hoped.
Let's talk about those emails that you just mentioned. Your Honor, we'll be displaying Exhibit 10, which has been pre-admitted. Mr. Lyman, what is this email referring to?
This is from the group that was doing the artwork for the NFT, and they're basically complaining that they don't appear to have sufficient funding to keep moving forward with the project.
Mr. Harper, if we could zoom in on that middle email, actually, that'll work too. Let's look at the email on the bottom. That's from Avery Ziegler.
Mm-hmm.
And what was Mr. Ziegler's role in this company?
He was the assistant to the chief artist development.
What does Mr. Ziegler say about the software and the hardware needed to get this job done?
He's not getting enough money to acquire what he needs to fulfill the promises, basically the presentation that we had made to the investors.
Let's talk about the email right above that. What was Charlie Young's role in this company?
He was, I guess, Avery's boss in the art department, the department that was responsible for turning this idea into an actual artistic expression.
What does the head of the art department say about the funding for the art department?
We don't have enough to do what we promised the investors to do, essentially.
Now, was Kirby Seaborn CC'd on this email?
Yes.
Did you ever see a response from Kirby Seaborn about increasing the funding?
No.
Were you ever told by Kirby Seaborn to allocate more funds to the art
I was
department?
not, no.
Mr. Lyman, be sure you wait until council's finished with their question before you answer. Court reporter can't take two people talking at the same time. Go ahead, counsel.
Yes, Your Honor. Were you ever told by Kirby Seaborn to allocate more funds to the art department after this email chain was sent?
No.
Let's switch gears and display exhibit number 11. Now, this is an email from Donna Moss. Who is that?
She was head of the department that was supposed to go out and sign up additional college athletes outside of Baylor.
Now, what sort of request does Donna Moss make in this email?
I mean, it's very similar to the Avery Fitzgerald and Charlie Young one. I don't get enough money to do what I'm supposed to be doing.
Did Kirby Seaborn receive this email?
He was CC'd on it, yeah.
Now, did you ever get a response from Ms. Seaborn, or did you ever see a response from Ms. Seaborn?
No, I did not.
Were you ever told by Ms. Seaborn after this email was sent to increase the budget allocated for the marketing department?
I was not.
Mr. Harper, we can take those down. Now, Mr. Lyman, was there ever a meeting with all of the department heads to discuss the product before it was actually released to investors?
Yes, about a week before the reveal date, everyone got together.
Now, when you saw the product at that meeting, was it the same as the product that you promised to investors?
No, it wasn't anything like it at all. I mean, it was it was a good old-fashioned baseball card, essentially.
What was missing compared to what was promised?
All of the technological sort of aspects of what was going to make this thing special. There's no video, there's no graphics.
Now, you mentioned that the goal for this company was to get athletes from across the country. At that final product meeting, were there any athletes from a school other than Baylor?
No, in fact, the pictures were the same three Baylor athletes that we had showed the investors initially.
Now, when was this product set to be released?
December 5th in 2020,
Who set that date?
Kirby.
Now, what?
Let me interrupt. Mr. Lyman, please refer to individuals by other than first name only, so we can keep the record straight.
Seaburn.
Now, at this final product meeting, did Ms. Seaborn ever suggest postponing the release date of this product?
No, not at all.
What happened directly after this meeting?
Well, as everyone was leaving, he kind of pulled me aside and kept me after everyone else had left.
And when Ms. Seaborn kept you aside after this meeting, what did she tell you?
Basically, that, hey, don't be worried about this. We're in the driver's seat because we got the money. They're stuck with whatever we do because we got their money. And so don't worry about the fact that what we showed them or what we're going to show them doesn't match their expectations.
How did the actual product release go?
Terribly. Obviously the investors were hugely disappointed when they saw the product or where the product was. The market took it out on them. The value that was assigned to the NFTs dropped about 90% that day.
Let me ask you this. After the product release went poorly, did Ms. Seaborn ever get the team back together to talk about what changes needed to be made?
No.
Did Ms. Seaborn ever talk to the heads of each department about improvements that could be made with the company?
No.
Well, then what did Ms. Seaborn do?
Fired us.
We pass the witness, Your Honor.
Cross-examination by the defendant.
Yes, Your Honor.
Please proceed.
I want to pick up right where you just left off and talk about why it is you're testifying here today. Sir, you used to be the CFO at College Cards, right?
I was, yes.
In July of 2020, College Cards first posted what they were planning, or their vision for what they were planning to give investors, right?
Yes.
In July of 2020, you didn't go to the FBI. and say you thought there was something wrong with the College Cards Company, right?
Why would I have?
Well, in July of 2020, you didn't think there was fraud, right?
Right.
And then in August, the company made $10 million, right?
Yes.
And in August, you didn't go to the FBI.
Why would I have?
In August, you didn't think it was fraud.
Right.
And the reason why you keep using this phrase, why would I have, is because you didn't have a reason to think it was fraud in August of 2020.
Yeah, I agree.
September, October, November. Sir, that entire time, you continued to work for College Cards, right?
I was employed by them to manage or handle the finances, and that's exclusively the only information I had about the operation of the company was what was in the bank account.
So you kept working for College Cards
I think that's what I said, yeah.
in the finance department.
Yes.
And for those 3 months, you didn't think that College Cards was engaged in fraud, right?
Well, the money was in the bank. I mean, where would I have seen the fraud?
So you didn't see any fraud.
No, because I wasn't part of the process of developing and marketing the card.
Sir, all I'm asking you is, as an employee of the company, managing the finances, you didn't see fraud, yes or no?
I didn't see any fraud in the areas that I was not overseeing because I wasn't paying attention to them.
So that was a no, right?
I believe so.
December 12th, 2020, you got fired, right?
Yes.
Fired by Ms. Siebel, right?
Yes.
And when you got fired, you were upset, weren't you?
Well, I was upset with this in the way it was handled, yes.
You were upset that your friend had let you go. She fired you, right?
I was upset at the way it was handled, is what I just said.
After you were fired, that's when you went to the FBI, right?
Mm-hmm.
It was only after you were fired that you told the FBI you thought there were any issues within this company, right?
What was then that I realized that there was fraud involved because when I was fired, it was obviously an effort to deflect what he had done to the rest of us in the company, and he was going to keep going the way he was going. And so it was time to tell somebody about what I had just realized.
Motion to strike the portion of the witness's answer where he said that that firing me was an effort to deflect from investors as an improper opinion.
Counsel, as I've told you earlier, if you think the witness is non-responsive, you need to raise it with me. I'll grant that motion. The witness is clearly offering opinions that are improper, and I'll direct the jury to disregard the witness's opinions about the reasons for his firing. But if you're going to let the witness go on and on beyond the scope of your question and not raise it with the court, then the witness is going to be able to continue to testify.
I understand, Your Honor. May I ask a clarifying question? If I ask a question and the witness is going on and on, you would like me to interrupt the witness and constructively approach you to talk about it?
I'd like you to raise it with me in an appropriate manner that you believe the witness is non-responsive.
Understood, Your Honor.
Same thing goes for the plaintiff. I'll police the witnesses. Counsel doesn't need to police the witnesses. You just need to say that you believe the witness has gone beyond the scope of the question that you've asked, and then I'll deal with it. If I disagree, I'll overrule your objection.
Yes, Your Honor.
All right? Let's proceed with the cross-examination.
Yes, Your Honor. I want to talk about some emails that you were talking about on your direct examination. You remember being shown a couple of emails?
Yes.
In those emails, you read that certain employees in the company, well, they were asking for more money, right?
Yes.
The artwork department asked for more money.
Yes.
The recruiting department asked for more money.
Yes.
Sir, you were the one who was managing the money within this company, right?
I wasn't allocating the money. I was writing the checks. And when Ms. Seaborn told me to write a check, I wrote a check or I deposited the money in the account. I had no control over how it was allocated.
Right, sir, but you knew where the money was going because you were the one writing the checks, right?
Right.
And so you knew that the artwork department got $250,000 from College Cards, right?
Yes.
You knew that the recruiting department got $250,000 from College Cards.
Yes,
Sir, that means the departments that you were telling us were kept asking for money, College Cards gave those departments $500,000, right?
that's what the records show, yeah.
So I want to talk about whether College Cards put that money to use. Sir, you recall seeing a tweet on the College Cards account in July of 2020?
Yes,
Mr. Trebasani, can we put up Exhibit 60? And for the record, this has already been pre-admitted. So this is the video that was in that tweet, right?
yes.
I want to compare in this is hold on, sir, my apologies. So this is the version of the trading card that College Cards tweeted, right?
Appears to be yes.
This is the version that they promised their investors, right?
I mean, yes, with the video, the moving video, yes, the digitalized version, yeah.
Let's see if investors got what they were promised. Mr. Trebasani, for the record, could we put up exhibit? Could you show me the exhibit? I'm sorry, sir, I don't remember the number. Exhibit 37. Your Honor, for the record, we're displaying Exhibit 37. It's also been pre-admitted. So, sir, Exhibit 37, this is a College Card, or this is the actual product that was released to investors, right?
Yes, it appears to be.
Let's compare the artwork. In both of these exhibits, they have the same color, right?
They do.
They have the same logo in the top left corner.
They do.
They have the same design, right?
Well, defined design.
They have the same, for example, there's a little area here at the bottom where there's sort of a scratchy looking piece of artwork here at the bottom left area, right?
Well, the simple image would appear to be the same, but the Exhibit 60 is not purely an image. You're comparing apples to oranges here.
Sir, both photos have the same little scribbly part on the bottom left corner, yes or no?
The surface image is the same, but as we've discussed, Exhibit 60 was more than just a surface, a facial image. Notice the little arrow in the circle that's missing from
Objection, Your Honor,
Exhibit 37.
Non-responsive.
I'll sustain the objection. Let's continue with the cross-examination.
I want to talk about whether College Cards delivered the athletes that they promised. Are you a Baylor's fan, sir? A Baylor's basketball fan?
Mm-hmm.
So you know who the man?
You need to answer out loud.
Yes.
Ken. All right.
So you know who the man in both of these images are, right?
Yes,
Someone named Davion Mitchell.
yes,
He's one of the players, the athletes on the Baylor basketball team, right?
yes, was.
And this was he was on the Baylor basketball team when Baylor won a championship, right?
Yes,
Now, in the photo in Exhibit 60, Davion Mitchell is in the video, right?
yes,
In the photo in Exhibit 37, Davion Mitchell is in the picture, right?
yes,
And so this college athlete is in both exhibits, right?
he's in a video and he's in a picture.
Thank you, sir. Nothing further.
You pass the witness?
My apologies, Your Honor. I passed the witness.
Is there redirect by the plaintiff?
Yes, Your Honor.
Proceed with redirect.
Mr. Harper, if we could actually get Exhibits 37 and 60 back up on the screen side by side. Bear with us, Mr. Lyman.
Final over the top from Butler.
Let me ask you this, Mr. Lyman. Was that a still picture?
No,
Is what we just watched what the investors got in December?
no,
Now, as the Chief Financial Officer of College Cards LLC, did you have the power to allocate funds to the department?
I had no independent discretion over fund allocation. I did only what Ms. Seaborn directed me to do.
We pass the witness.
Is there further cross-examination?
None, Your Honor.
May you step down, Mr. Final? Plaintiff, call your next witness.
Yes, Your Honor, the plaintiff calls Shay Bartlett.
All right. Please take the stand, Ms. Bartlett. You've been previously sworn. Please proceed with direct examination.
Good afternoon. Could you introduce yourself to the members of the jury?
Yes, my name is Shay Bartlett.
What do you do for a living?
I'm an investor of sorts, kind of a dealer on the cryptocurrency markets.
Now, how did you get involved in this sort of work?
Well, my mom was an investor a while ago. She's kind of retired now, but she put that interest in me to, go search for the next big thing. So it's kind of been something I've been involved in since I was little, that I've seen since I was little, and that now I've been working in myself for a couple of years.
Have you invested in the defendant corporation's business, College Cards LLC?
Yes, I have.
Now, have you been sitting in court all day today?
Yes, I have.
Have you heard defense counsel say that the product you were promised is the product that you got?
Yes, I've heard them say that.
Ms. Bartlett, let me ask you, is that the case?
No, absolutely not.
So let's take a step back. Why did you decide to invest in College Cards?
So I, as part of my job, I go on these social media sites, and I was on Discord one day, one of these sites, and I saw these images posted. But they weren't just images, they were videos. And they had taken this idea of trading cards, which were booming during the pandemic, and they'd made them into these videos that showed highlight reels, and they were flashy and they were exciting. And I immediately went and followed the share, Kirby Seaborn, on Twitter, so I could get involved and see how I could, be a part of this.
How much did you invest in College Cards LLC?
So in dollars, rather than, it was about 9 ETHs, but in dollars, $30,000.
Did you ever receive an opportunity to sell the mint passes that you bought?
Yes, I did.
Did you make that sale?
No, it was right before the anticipated release date, and I thought the offer was kind of a low ball, so I denied.
So when the product was released, did you still own the investment? Did you still own the mint passes?
Yes, I did. I had all 3 mint passes.
When the product was released, was it what you expected?
No, so on December 5th, when all this happened, I go on to my mint pass and I refresh to get my Nifties, and I can't even, I was just shocked. It was such a disappointment.
When you say it was a disappointment, why?
You've seen the videos. You've seen what I saw a couple months before. I was expecting these great videos, these highlight reels, and what I got was basically what I could have gone to a local, collector's store and gotten on a piece of paper. And it wasn't flashy, it wasn't exciting, it was boring, honestly. And that's not the only thing that disappointed me. I also was expecting other college athletes. I'm not really a Baylor fan, but I was promised that this company was going to go out and find all different kinds of college athletes, a huge variety. And what I saw on December 5th was the same athletes that I saw a few months before.
Let's talk about what actually happened to your investment. Tell us about the value of the products you received now.
So that exact same day, it had already started to drop. I went on OpenSeas, which is a forum for that sort of thing. And the value, what was previously 3 ETHs, was now 0.3, 0.2. And today, I think the most recent one I've seen, it was 0.1 ETHs.
Have you lost money on your investment in College Cards?
The value, yes, it's dropped, 90%. I haven't sold mine. I still own them today, but the value has dropped a lot.
Ms. Bartlett, why do you still own the products that you bought from College Cards?
Well, part of it is because they are worthless. What's the point in selling if I'm going to get, cents on the dollar for what I paid? But there also is always the hope that it could increase in value at some point in the future. So
Ms. Bartlett, when you first came across College Cards LLC, were you in the business of buying their sort of product?
yes, I was.
Do you feel like you were misled by the statements made by members of this defendant corporation?
Absolutely.
Would you have invested in this product if you hadn't seen the videos that we've watched a couple of times today?
No, I wouldn't have. That was the whole point. That's why I got so excited about it.
Pass witness.
Cross-examination by the defendant.
Yes, Your Honor.
Please proceed.
I want to pick up right where you just left off with your attorney. You just testified that you felt like you were misled by College Cards.
Yes, that's right.
Ma'am, I want to explore whether you got what you were promised. Let's start with the artwork. Mr. Travesani, for the record, we're displaying exhibits 60, 1, and 2. Ma'am, these are the videos that you saw when you were interested in investing in College Cards, right?
Yes, it's like a freeze frame of those videos. Yes.
Freeze frame of all of the videos that you were interested in, right? Or excuse me, all the videos that you saw when you were looking to invest.
Yes, that's right.
I want to compare these videos to what you got. Ma'am, or excuse me, for the record, we're displaying exhibit 37, 36, and 35. Let's compare the artwork and what you thought you were going to get and what you got. In all of these photos, the border is the same, right?
That's true.
The colors are the same.
Yeah, they are.
The logo is the same.
Sure, yes.
Let's talk about whether you got the athletes that you were promised. In the top row, we see 3 athletes, right?
Yes.
Davion Mitchell, right?
Yes. Sorry. Yes.
Jared Butler, correct?
Yes.
Mark Vital, right?
Yes.
Ma'am, what you got were 3 athletes.
Yes, these same 3 athletes.
Exactly. You got the same athletes that were in the videos that you saw, right?
Yes, but that's not what I was promised.
You got Davion Mitchell.
Sure.
You got Jared Butler.
Sure.
You got Mark Vital.
That's right.
Now, you said that's not what you were promised, ma'am?
Yes, exactly.
Ma'am, these were the exact athletes in the videos that you watched.
In the promotional artwork, yes.
The exact athletes in the videos you watched before you invested into this company, right?
Sure, yeah.
So then let's talk about the video. Now, you're telling this jury today that what you thought you were going to get was a video, right?
Yes.
But ma'am, before you invested money into this company, you actually went to a Twitch live stream hosted by College Cards.
Yes, that's right.
A Twitch live stream where they were talking about the products that you were going to get.
Yes, with Miss Seaborn over there.
In that Twitch live stream, you were told that what you were going to get, or excuse me, that the videos were conceptual, right?
Objection, Your Honor, to hearsay.
May I respond?
Please respond.
Your Honor, this statement that the artwork is conceptual is not being offered for the truth of the matter asserted. In fact, our client has already testified that the artwork was conceptual, that it was her vision. At this point, we're offering this to demonstrate that what she is claiming she expected to get from the company is not actually what she was told she was going to get from the company.
I'll overrule the objection, especially in light of the fact that the court expects Ms. Seaborn to testify in the defendant's case. She can address it herself at that point.
Yes, Your Honor.
Let's proceed.
So you went to this Twitch live stream, and this was a live stream hosted by College Cards, right?
Yes, that's right.
And during this Twitch live stream, you were told that the artwork was conceptual, right?
Yes, or promotional, something along those words.
Well, the exact word was conceptual, right, ma'am?
Sure.
Nothing further. Or, Your Honor, I passed the witness.
Is there redirect by the plaintiff?
Yes, Your Honor.
Please proceed.
Ms. Bartlett, when the defendant corporation showed you a product that they called promotional, were you aware that they hadn't yet made any artwork of their own?
No, I actually think I was told that that was their artwork.
Why don't we pass the witness?
Is there further cross?
None, Your Honor.
All right. Witness may step down.
And Your Honor, with that, the plaintiff rests.
All right. The plaintiff has rested the plaintiff's case in chief. Does defendant have a motion to offer at this point?
Yes, Your Honor.
Please proceed with your motion. I assume this is under Rule 50A.
It is, Your Honor. The defense moves under Rule 50 for, sorry, Your Honor. Under Rule 50,
50A of the Federal Rules of
50A of the Federal Rules of Civil Procedure for judgment as a matter of law. Because viewing the light and the evidence most favorable to the non-moving party, the plaintiff, no reasonable jury could find that they have met their burden. Specifically, they have failed to show that College Cards made a false representation. Today, we heard that College Cards posted on their Twitter account that they were going to have a certain artwork and that artwork was going to include certain athletes. We also heard that the specific artwork that the investors got, it had that artwork, that aesthetic, and it had those athletes. That demonstrates that there was no false misrepresentation. If there's no misrepresentation, there's no fraud.
What's the plaintiff's response?
Yes, Your Honor. As it relates to a material misrepresentation, we've seen a lot of different versions of the same product, but what we have in evidence is a tweet from the CEO of this company saying, "You've seen our artwork." On the stand, the CEO of the defendant corporation admitted that there was no product at that time. In addition, we've already heard from Ms. Bartlett that she had an expectation based on representations made by the defendant corporation through their actions, through their tweets, and through their promotional meetings, that there would be videos and that there would be athletes from across the country. That's sufficient evidence to create an issue of fact and send this to the jury.
All right. The defendant's motion is denied. Counsel, before we proceed with the defendant's case in chief, we'll take a short recess, approximately 5 minutes.
Yes, Your Honor.
Court stands in recess. Defendant, are you prepared to proceed with your case in chief?
Yes, Your Honor.
Call your first witness.
Defense calls Kirby Seaborn.
All right. Ms. Seaborn, if you'll return to the witness stand, I remind you, you remain under oath. Proceed with direct examination.
Yes, Your Honor. Ms. Seaborn, I know we've all already heard from you, but I want to give you the opportunity to address one of the claims that the plaintiff just made. Did you hear the plaintiff say that she expected to get videos in her trading cards?
I did.
I want to talk about whether that expectation was warranted. Now, throughout the course of running your company, how do you communicate with investors like the plaintiff?
Well, a lot of it was done through Twitter and social media.
I want to take a look at your tweets. Your Honor, at this time, the defense offers Exhibit 13 through 25 into evidence. These are some of those exhibits that we talked about in the beginning of trial, exhibits that there were no objections to.
Any objection at this point?
No.
They'll be admitted. Let's proceed.
Displaying Exhibits 13 through 26. Ma'am, I see there's a lot of tweets here. Are they all from you?
Yes, they are.
In any of these tweets, did you ever write that investors should expect to get videos?
No, that's not something that we promised.
Did you ever say we were going to give you video trading cards?
I never said that.
And so when the plaintiff says she expects video trading cards, is that what you promised to the plaintiff?
No.
Thank you. Nothing further. Or pass the witness.
Cross-examination by the plaintiff.
Yes, Your Honor.
Please proceed.
Ms. Seaborn, I want to talk about something that you decided not to tell your investors. Mr. Harper, if we could get Exhibit 4 on the screen, it's one of those documents we agreed was admissible. And if we could go to the second page. This is all an email chain between you and your head of the art department, right?
Yes, I believe so.
Let's zoom in on that fourth bullet point. The head of your art department says may want to mention that the demo artwork is just our vision for what the eventual cards will look like when they're released, and that they were not created by the College Cards team. That's what your head of art told you, right?
Yes, that's what he wrote.
Mr. Harper, let's move back to the first page and look at your response, Ms. Seaborn. Now, in your response, you talk about bullet point number 6, right?
Oh, yes, I do.
That's the bullet point that we just discussed.
Yes, it's the same one.
You said, don't see why that's relevant, right?
That's what I wrote.
You said that the bullet point that talked about telling your investors that the artwork wasn't yours might scare some people off.
Yes.
Let's talk about what you did tell the public and your investors, though. Mr. Harper, let's pull up Exhibit 16. This has been pre-admitted. What you do tell the public, don't do your own research.
Yes, that's what I posted on Twitter.
You told the public not to look into your company.
I told them not to do their own research, yes.
You told your company not to look into your product. You told the public and your investors not to look into your product.
I said not to do your own research, yes.
Now let's talk about why your product may have failed. Mr. Harper, if we could display Exhibit 10, it's been previously admitted. This is an email chain where your art department requests more money, right?
That's what this appears to be, yes. But I'm not really an email person. I communicated mostly over Discord.
Your art department, specifically Avery Ziegler, a member of that department, said that he didn't have enough money to buy the software or the hardware he needed to get the job done. Isn't that true?
That's what this email represents, but I don't believe I ever actually read this email.
Your Honor, move to strike everything after yes as non-responsive.
Ms. Seaborn, you need to limit your answers to the questions asked. I'll sustain the motion and direct that everything beyond where she said that's correct, that's what the email said, be struck from the record.
Yes, Your Honor. Your art department called the budget you gave them a shoestring budget.
Yes, that's what it says.
You gave them $250,000.
I did, yes.
You had $10 million to give.
Yep, that was the total.
For the product you released in December, you gave them 0.25% of the money you had available.
Yes, 250,000.
Mr. Harper, if we could zoom out, you're CC'd on that email that we were just looking at, right?
It appears so, yes.
So you did receive this email.
I was CC'd on it.
You're telling us you never read an email from your staff requesting more funding to get a product finished?
Like I said, I'm not really an email person. I did all of my business over Discord.
So you're telling us that you run a multi-million-dollar tech company, you don't read your emails?
No, I'm a Discord person.
Let's
It's a
move
new
to
thing.
Let's move to Exhibit 11, which has also been previously admitted. Ms. Seaborn, we got the same story, but this time it's your marketing department, right?
Yes, it appears so.
They asked for more money
It appears so, yes.
because you've only given them 0.25% of the budget.
That's correct.
You never answered,
To the email?
correct?
No, I never saw it.
You never gave your marketing department more money
No, I never saw the request.
because you're the CEO of a multi-million-dollar tech company that didn't want to check your emails.
As I said,
Asked
yes.
and answered?
Overruled.
Because you're the CEO of a multi-million-dollar tech company, but decided not to check your email.
Like I've said, yes, that's correct.
But let's talk about what you didn't ignore. Your Honor, permission to display Exhibit 50, which has been stipulated to be admissible.
If it's admitted, you may display it.
This is another conversation with Charlie, the head of your art department, right?
Yes, it appears to be.
Again, Charlie asks you to think about pumping more money into the art, right?
Yes, that's correct.
Charlie asks you to consider delaying the reveal.
Yes,
Your art department wasn't sure they were going to have the product in time.
that's what the text message says.
So you knew that these problems existed.
That's what the text says, yes.
Well, you responded to this text, correct?
I did. I said, you know, not to put stuff like that in writing and to come see me since I answered stuff over Discord.
You didn't increase the funding after receiving this text.
No,
You didn't push back the release date after this text.
no, I didn't.
All you said was you know not to put stuff like this in writing.
Yes, because like I said, I'm a Discord person.
Well, let's take a step back and talk about why this company exists at all. Your Honor, we'll be displaying Exhibit 56, and again, pre-admitted. This is a text conversation between you and your best friend, Avery Ziegler, right?
Yes, I believe so.
This is a conversation that occurred before you ever got money from any investors.
Yes,
You're asking Avery Ziegler to come work for you at this company that you own now.
yes, that's correct.
But, Ms. Seaborn, you don't call it a company. you?
Not in this exchange, no.
You call it one of the most foolproof get-rich-quick schemes of all time.
Yes, as a way to tell to her parents.
Your Honor, we pass the witness.
All right. Is there further direct examination?
Yes, Your Honor.
Please proceed.
I want to address the email in Exhibit 4. Mr. Trevisani, can we put that up? And could we zoom in on the response that Ms. Seaborn had? Your Honor, for the record, we're displaying Exhibit 4. Ma'am, during cross-examination, opposing counsel read the first line of the sentence. Do you remember her reading that to you?
I do.
What does the next line say?
It says, I think we've made it clear enough that this is just demo art, but I'll think about it.
Why did you write, I think we've made it clear enough that this was just demo art?
From the other tweets that we put out that showed that this was just what we envisioned it would eventually be like.
You're saying that you put this out via tweet. I want to take a look at that tweet. For the record, we're displaying Exhibit 60. Ma'am, is this the tweet where you put out the video?
Yes, it is.
Is this the video you were discussing in Exhibit 4?
Yes, that's correct.
And what do you say in this tweet?
I'm saying that take a look at what we envision for our college cards to look at.
I want to talk about the text message that you just looked at, the get rich quick text message. For the record, we're displaying Exhibit 56. Ma'am, opposing counsel just read the part where you said, most foolproof, get rich quick scheme of all time. Do you remember her reading that to you?
I do.
Well, I want to give the members of the jury the full context of these text messages. Who is that person in green?
That would be Avery.
And what is your relationship with Avery?
Avery is a good friend. He later became, or is still, the acting art director.
Let's use complete names here, please.
Yes, Your Honor. Mr. Avery Ziegler.
So when your friend, Avery Ziegler, sent this text message to you, what is it that he said? And you can read the whole thing.
He said, you know, I would love to, but I just don't know. I mean, how do I even tell my parents about it? Oh, hey, Mom and Dad, I'm dropping out to move to Waco, Texas. Yeah, the Magnolia place. To make online trading cards with Kirby. Okay, see you later. I can just picture their heads exploding all over the dining room table.
Who is the person who responded here in gray?
Oh, that's me.
In this first part of your response, you say, just tell them. Who are you referring to when you said them?
Well, his parents, of course, since they were worried about him coming here.
So when you wrote, just tell them, meaning your parents, that you're going to join a get-rich-quick scheme. Were you being serious?
Of course not. It was just a joke to try and alleviate some of the concerns that his parents had about dropping out of college to start a new startup company.
And after you wrote get-rich-quick scheme, what was your next words?
Ha, as in haha, since it was a joke.
Thank you. Pass the witness.
Is there further cross-examination?
No, Your Honor.
All right, you may step down, Ms. Siegler. Defendant, call your next witness.
Defense calls Avery Ziegler.
Please bring in Ms. Ziegler. Mr. Ziegler. You'll take the witness stand, please, Mr. Ziegler. You've previously been sworn.
Yes, Your Honor.
Counsel, you may proceed with direct examination.
Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the folks in the jury?
Hi, my name is Avery Ziegler.
How old are you?
I'm 22.
Are you currently in college?
No, I'm not. I was, and I dropped out to join College Cards.
What encouraged you to join College Cards?
Kirby came to me with the idea, and she told me what it was, what we were working on, and the demo images. And it seemed like a good idea and something that I would like to do.
And just for the record, when you say Kirby, you're referring to Kirby Seaborn?
Yes, I am. I'm sorry.
I want to talk about what the College Cards company does. Do you know what it is that College Cards sells?
Yes, so they're, we call them Nifties, but they're basically online trading cards.
And those trading cards, do they have professional athletes or college athletes?
Yes, that's correct.
Or which is it? Is it professional athletes or college athletes?
Oh, I apologize. College athletes.
What makes the trading card special?
Well, we try to work on a lot of the artwork on the card to make it really pop so that it's not just a picture of the athlete.
So I want to talk to you about the artwork. What department in College Cards do you work in?
So I'm actually the head of the art department.
Now, back in 2020, were you the head of the art department?
No, I was in the art department, but I wasn't the head yet.
And while you were in the art department, did you see any issues with how the art was developing in 2020?
It wasn't coming along as fast as we hoped that it would, but we had the pictures of the athletes that we wanted and we're getting the artwork done.
You say you have the pictures of the athletes that you wanted. Who are you talking about?
The athletes that were on the cards that were finally released, Vital and the others.
What school did those athletes come from?
Baylor University.
Are you a fan of Baylor basketball?
I am a Baylor Bear, yes, or a fan.
So, sir, having a Baylor, so are the Baylor basketball team, is the men's Baylor basketball team, are they any good?
Yes, they are. They're very good.
How do we know?
Well, they're champions.
How is it that College Cards was able to get, basketball champions on these cards?
That's really a different department for me. I made the artwork once we got the pictures, but how we arranged that was really not something I did.
Are you aware of whether or not College Cards got any licensing agreements with those athletes?
I don't know.
But sir, in the work that was ultimately published to the investors, did it have those athletes?
Yes, it did.
Thank you. Pass the witness.
Cross-examination.
Yes, Your Honor.
Please proceed.
Mr. Harper, if we could show Mr. Ziegler Exhibit 56, which has previously been admitted. Mr. Ziegler, these are texts between you and Kirby Seaborn.
Yes.
This is before you joined College Cards, LLC.
Yes, it is.
It's before you even moved here to Waco.
Yes.
In these texts, Kirby Seaborn does not call College Cards a company.
No, he doesn't mention it specifically.
She doesn't call it a business.
No, she doesn't.
She calls it one of the most foolproof get-rich-quick schemes of all time.
No, that's what she said that I should tell my parents.
About the business that you moved here to be a part of.
Yes.
We can take that down, Mr. Harper. Thank you. Let's be clear about something. Kirby Seaborn's one of your best friends.
Yes, she is.
And when you joined the company, you were a member of the art department, right?
Yes, that's correct.
But you weren't actually the head of any of the departments.
No, I was not.
Well, let's get a layout of all the employees that were actually on this staff. Your Honor, permission to construct a visual aid using Mr. Ziegler's testimony?
Granted.
All right, so Kirby Seaborn was the CEO, right?
That's correct.
She was the one in charge of it all.
Yes.
There were 3 departments, right?
Yes, that's correct.
There was finance.
Yes.
Finance was run by Casey Lyman.
Yes, that's correct.
There was marketing and athlete outreach.
Yes.
That was run by Donna Moss.
Yes.
There was Charlie Young.
Yes, Charlie was there.
Charlie ran the art department.
Yes,
Charlie was your boss.
that's correct.
And then you were below those 3 as a member of the art department.
Just below Charlie, yes.
When you joined this company, you were making $75,000 as a salary, right?
That's correct.
That was your starting salary.
Yes, it was.
And you knew that with that salary, you were making more money than your supervisor, Charlie Young.
That's correct, yes.
You were making more money than the head of marketing and outreach, Donna Moss.
That's correct.
You were making more money than the head of finance, Casey Lyman.
That's also correct.
Now, when the product failed in December, Mr. Harper, actually keep that up, please. When the product failed in December, changes were made to the staff, right?
Well, I don't know that I would say that it failed, but yes, there were changes made to the staff.
Well, when the product was released in December, staffing changes were made right after.
That's correct, a few days afterward.
Charlie Young lost his job.
That's correct.
Donna Moss lost her job.
Again, that's correct.
Casey Lyman lost her job.
Yes, she did.
But you kept yours.
Yes, I did.
You got to stay at the company run by your best friend.
Yes, that's correct.
In fact, you got a raise.
I did. It came with the promotion.
Now you make $100,000 a year.
That's correct.
Your best friend called it a loyalty bonus.
That's correct, yes.
You're still the head of the art department, right?
Yes, I am.
Sitting here today, you've still got a $100,000 salary.
That's correct.
No product has been released by this company since December of 2020.
That's correct.
For a year, this company has not released any more art.
That's correct. We've had the lawsuit going on.
There's been no more art development.
That's correct. We're still thinking of ideas, but nothing on the paper or on the computers.
There's been no more marketing.
That's correct.
There's been no more hires.
That's correct.
Sitting here today, this company has 2 people,
Yes,
you and your best friend,
that's correct.
and a budget of $9 million.
The budgeting is not really my department, so I don't know how much is left.
Well, you've still got your salary of $100,000.
That's correct.
Pass the witness.
Redirect.
Yes, Your Honor.
Please proceed.
I want to go back to those texts that opposing counsel showed you during cross-examination. Do you remember seeing texts between you and Kirby Seaborn?
Yes, I do.
And in those texts, she used the words get rich or foolproof, get rich quick scheme. You remember reading that?
Yes, that's correct.
What was the context of those text messages?
Well, she was asking when I was going to be moving to Waco to join the company. And I told her, how would I even explain that to my parents? Because I was in school at the time. And so I said to say that I was dropping out to go and work with Kirby on some trading cards, I could just see their heads exploding. And so her response was to joke and say, oh, you should just tell them you're joining a quick get rich quick scheme. So it was just kind of a funny way to ease the tension of trying to tell my parents.
And so to clarify, when she used those words to you, get rich quick scheme, did you think she was being serious?
No, absolutely not.
Did you actually end up working for the company?
Yes, I'm still working there.
Would you work for this company if you genuinely believed it was a get rich quick scheme?
No, ma'am, I would not.
Since working for the company, has Ms. Seaborn ever made any statements to you about wanting to get rich quick?
No.
Has she made any statements to you saying that she wanted to lie or defraud her investors?
No, absolutely not.
Thank you. Pass the witness.
Is there a redirect?
No, Your Honor.
You misstepped down. See? Defendant, call your next witness.
Defense calls Dallas McGarry.
All right, let's bring in Dallas McGarity. Will I have a seat at the witness stand, please, Mr. McGarity? You've previously been sworn. Counsel, you may proceed with direct examination.
Yes, Your Honor. Could you please introduce yourself to the members of the jury?
I'm Dallas McGarry.
What do you do for a living, Mr. McGarry?
I'm retired, or perhaps you might say semi-retired.
What do you mean by that?
Well, I started my career back in the 90s with Google. I was involved there with coding the algorithms. And I also was involved in some aspects of what I'll call the bigger picture as Google went through its startup phases.
So you say you're semi-retired. Why aren't you working now?
Well, I received stock options during my time with Google. And by the time we rolled around to 2000, 2001, things had completely taken off. And I was relatively young. I was in my early 30s, but put it bluntly, I made a lot of money. And I decided just to get off the hamster wheel and go on my own.
Okay, but now you said you were only semi-retired. Do you do any work?
I'm an adjunct professor at Stanford Business School.
What do you teach?
I teach a course called Bitcoin and Crypto, Everything You Need to Know.
I want to talk about how much you know about the subject that you teach. Do you have any educational background?
Yes, I do.
Could you tell the members of the jury about that background?
I have a degree in computer science and in finance from Stanford Business.
And what is it that you teach in your class at this point?
Well, I teach about these developing technologies, specifically about Bitcoin, cryptocurrencies, NFTs, or what we call NFTs. It's been a very rapidly developing area for us, and we have found that the undergraduates were trying to create leaders in the economy and in industry, and it's frankly a very popular course.
Now, I want to talk to you about your involvement in this case. Were you asked to review college cards for this case?
Yes, ma'am.
Were you asked to review when College Cards released trading cards to investors?
Yes, ma'am. Mm-hmm.
Let's take a step back. Before you were asked to review College Cards for this case, did you already know anything about College Cards?
Well, yes. After I left Google, as I say, I'm kind of semi-retired. I had been very blessed with financial resources, and so I guess you might say that I was only semi-retired because I spent a lot of time in personal investments. I've always been fascinated, coming from Google and my background, in what's happening in terms of startups in the tech space. And I followed about everything back around 2005, 2008. I assiduously followed what was happening with cryptocurrency and Bitcoin, and then you roll on a number of years, about a decade or so, until I guess, I don't know, around 2017, 2018.
My apologies, Professor. I hate to cut you off, but I just want to ask a more narrow question.
Sure, surely, yes,
Were
ma'am.
you familiar with College Cards in 2020?
Yes, ma'am.
How were you familiar with College Cards in 2020?
I have a podcast on these technologies. It's called the Crypto Report, and I was contacted by the lawyers.
Now, in 2020, do you remember when College Cards released college trading cards out to their investors?
Yes, ma'am. I've always been in trading cards, even the old style trading cards, baseball, basketball, Magic, Kareem,
Okay. So college,
Shaq.
understood, sir. So College Cards releases their cards back in 2020. What was your first impression of that? What was your first impression of that release?
Well, I was interested. I thought, wow, this is trading cards, but in a nifty form. And I was intrigued by the possibilities for the technology.
You say you were intrigued by the possibility. Did you actually end up investing in the company?
No, I did not.
Do you remember when the company released their college cards to their investors?
Yes, ma'am, I remember that.
Did you go to on your podcast at that point?
Yes, ma'am.
What did you say about that release on your podcast?
Well, I was pretty negative on the release. I guess you could say I kind of dissed it.
Dissed it in what way? What exactly did you say?
Well, when it was released, the Nifties just had an image of the collegiate basketball players. That was it.
And so, did you think that the release was fraud or a rug pull when you first saw it?
Yes, I did. I on my podcast, I even described the release as a rug pull.
Now, since having that initial opinion, have you changed your opinion about college cards?
Well, it might be best to say that I know more about what happened. As I've already mentioned, I did not invest in it. I did my research. I'm, as I say, very careful about my research. I'm in a position to really spend some time and determine whether an investment is a good investment. And what we were dealing with here, I thought, were some young people that were very charismatic in their presentation of the technology to me. That's not unusual with startups, as I think we all well know.
Mr. McGarry,
yes.
again, I hate to cut you off, but I want to ask you a little bit more of a specific question,
Yes,
sir.
ma'am.
Let me put it this way. Do you still believe that College Cards is engaged in any fraud?
No.
Now, before you changed your opinion that they weren't engaged in fraud, did anyone at College Cards pay you to
No,
come
ma'am.
up with that opinion?
No, ma'am. No.
Have you ever made any money off of this company?
No, ma'am. I have not.
So I want to talk about what it was that caused you to change your opinion on College Cards.
Yes, ma'am.
After that initial opinion, did you look more into the company?
Yes, ma'am.
Did you look at the tweets that the company's CEO put out?
Yes, ma'am.
Once you looked more into the company, why is it that you no longer believed it was fraud?
Well, they had an idea, they had a vision, and it was only a vision. They never presented what they were going to do as anything more than that.
And I want to break that down a little bit. When you reviewed what this company actually said, did they ever tell investors that they were 100% going to give them videos?
Well, no, ma'am. No, that would be ill-advised. They would not do that. I don't think any startup would do that. You speak of 100% certain. No, of course not.
Did they ever tell investors that they were going to get college cards with animations on them?
They had some demos that had animations on them, but they never represented that what they were going to present eventually when the product was launched would be the same. They just said, this is, in essence, what our vision is like. This is what we're thinking about. We're thinking along these lines, essentially.
Now, when College Cards first released their vision, did it have college athletes in it?
Yes, ma'am.
Now, the cards that the investors got, did they have those college athletes in them?
Yes, ma'am, they did.
Thank you, sir. Pass the witness.
Cross-examination by the plaintiff.
Yes, Your Honor.
Please proceed.
Mr. McGarry, College Cards LLC was on your radar before they ever actually released a final product in December of 2020.
Yes, ma'am.
You knew that they had a product in the works?
Yes, ma'am, I did.
And at the time, you were someone who was making investments in companies and products.
Yes, over the years as I have referred to, my semi-retirement, I was into investments, and in particular, I had an interest in investments in this technological startup space.
Your Honor, move to strike. The latter portion of that answer is non-responsive.
Sustained.
Mr. McGarry, you knew that College Cards LLC was creating a digital trading card, right?
Yes, ma'am.
You knew that they had a product that was going to come out in December.
Yes, ma'am.
Now, you told us a minute ago that the company never said that there would be videos on the final product, right?
That is correct, yes.
You told us that they never said explicitly that there'd be animations.
That is correct.
However, when the product was released in December of 2020, you were surprised by what you saw.
I was, yes.
They released a product that was different than what you expected.
Well, the product, I don't feel was up to the standards that they had presented it would be.
The product was different than what you expected.
Well, they had only represented that they were thinking along the lines of the demos. So I will let others draw conclusions.
On our move to strike, the entire answer is non-responsive. I haven't gotten a yes or a no.
Overruled. I think the witness is attempting to be responsive. Let's move along.
Mr. McGarry, when you saw the final product, you called it trash.
I was critical, yes.
When you saw the final product, you called it a rug pull.
Yes, ma'am. I did use that term on my podcast.
Since that time, you are not aware of any new product that College Cards has released, correct?
No, I'm not.
You haven't seen any improvements to the product that you first called trash.
No, ma'am. I have not been aware of any further business ventures by College Cards.
Thank you. Pass the witness.
Is there a redirect by the defendant?
None, Your Honor.
You may step down, Mr. McGarity. Defendant, call your next witness.
Your Honor, the defense rests our case in chief.
All right. Counsel, both parties having presented their case in chief, we'll proceed with closing arguments. You have the jury instructions that have already been negotiated and established. I've presented these jury instructions to the jury, and we'll proceed with the closing arguments by counsel. Is there anything either party's aware of that we need to take up before we proceed with closing arguments?
No, Your Honor, we're ready to proceed, but if time permits, we would request a brief recess before moving into closings just to collect everything we need.
All right, I see no reason why we can't do that. We'll make it short. The court will take a 5-minute recess.
Yes, Your
We
Honor.
reconvene, we'll take up closing arguments. Court stands in recess. Be seated, please. We'll proceed with closing arguments, the jury having already been charged. Plaintiff, you may present your first closing argument.
Yes, Your Honor. May it please the court,
Please proceed.
opposing counsel, members of the jury. It was a fake product, but it was real fraud. It was a fake product, but it was real fraud. This defendant corporation was never going to make the product they promised to investors. Why? Because their CEO would stand in their way at every single opportunity. This corporation lied to their investors, to the public. This is a case about real people who had real expectations for what they thought would be a real product. It's a case about real people who gave real money to this defendant corporation And in return, all they got were broken promises. That's fraud. That's why Ms. Bartlett has brought a claim of fraud against the defendant corporation. Now, with this claim came a burden to prove that claim by a preponderance of the evidence, meaning that today, we just had to show you it was more likely than not that it was a fake product, but real fraud. We had to show you 4 things. We had to show you that there was a material misrepresentation that was made. We had to show you that it was recklessly made by this company. We had to show you that Ms. Bartlett relied on these promises and that she justifiably relied on a product that caused her harm. We've met that burden today because what you've seen today was the life cycle of this defendant corporation scheme. They made a promise to investors. They raised the money from investors. They broke their promise to investors, and they kept the money. That's the life cycle of the scheme. They made the promise. They raised the money. They broke the promise. They kept their money. That was what this business was. So let's walk through each part of that cycle. Starting with making a promise. Now, today you have heard a lot of talk about what the promises made by this corporation actually were. But let's be clear about something. The CEO of this defendant corporation walked up to investors and said, here's what we want. Here's what we're going for. Immediately after, she said, you've seen our artwork. That was a lie. What she did was create an expectation. The CEO of this corporation didn't need to say, we're going to give you videos. She showed the investors the videos that they expected to receive. She didn't need to say, you're going to get athletes from every single part of the country because that's what they said they wanted to do. She walked into a room full of investors and said, here's what you should invest in. They invested, they didn't get it. And now the CEO is trying to say, well, if you read the fine print, I wasn't that clear. So no, I didn't make any promises whatsoever. Think about it like this. The investors of this company had an expectation for what this product would be because the CEO of the defendant corporation created that expectation. I mean, the defense's own witness sat on the stand and told you exactly that. When Mr. McGarry was sitting here telling you that as a potential investor, he had an expectation of what the product would be, he also told you his reaction. It was different than the expectation that this company created. Whether it's written in stone or not, they made a promise. They made a promise through their actions. They made a promise through the expectations they created for the investors they were trying to get money from. They made a promise for a product they did not deliver on. It is as simple as that. The next step, getting the money. Today you heard about 1,000 investors that believed that this corporation would make the product they created that expectation for. $10 million went to this defendant corporation overnight. Now they had the money. All they had to do was make a product that failed. That's the next step of the rug pull former FBI agent Jamie Craig told you about. You see, when former agent Craig was walking you through the steps of this common cryptocurrency fraud scheme, she told you that it starts with creating this expectation. The next step is getting the money, but then things get more blurry with what the company does with that money. You see, that's where we get to this third part of this scheme. It's breaking the promise. Remember this. There were $10 million to spend on this product. This company spent 5% of that for a product that wasn't up to standard, for a product that didn't meet expectations. There is no good reason why. Today, you saw emails from the art department and the marketing department saying, Ms. Seaborn, we need more money. There's hardware and there's software that we need to get our product done. We can't do it. We can't reach out to the athletes we told our investors we'd get. We don't have the money. In response, nothing. Today, the CEO of a multi-million-dollar tech company asked you to believe that the budget for her departments were cut off at the knees because she doesn't read her email. Think about that. Think about why that might be the reason. It's easy to say you didn't give funding because you didn't know there were requests. The only alternative to the CEO saying that she didn't see the emails would be to say that she saw the emails but decided that this product wasn't worth actually giving sufficient funding to make it what investors expected. The CEO of this company had the money to make the product that investors expected. She had the ability. She chose not to take it. Now, the defendant CEO can sit here all she wants and tell you that she didn't know about the funding. That's how the story started. She didn't know that there was insufficient funding. She didn't know that her departments were asking for more time, more money, but then she had to get confronted with her own text messages. When emails didn't work, she got a text from the head of her art department. What did it say? Exactly what Ms. Seaborn denied knowing about. That the art department needed more time. That the art department needed more money. Ms. Seaborn didn't give them more time. Ms. Seaborn didn't give them more money. She gave them a deadline they couldn't meet. She gave them a budget they couldn't work with. Why? So that the product could fail. Because that's the last part of this scheme. Keeping the money. You see, when Jamie Craig was on the stand today, she explained to you the way that cryptocurrency investments actually work. An investor buys a mid-pass, and that's what they've paid for until the product gets released. When the product gets released, it goes straight to the investors, and once it's in the investor's hands, the developer can't touch it anymore, can't change it anymore, can't spend money on it anymore. On December 5th of 2020, this company released the product to their investors. That was a date that this defendant corporation set on their own. They'd spent 0.5%, or 5%, of their budget. And when they released that product, the rest of that budget, over $9 million, it couldn't be used on the product anymore. It couldn't be used to create a product that their investors expected. So then what happens with it? Well, you see, this defendant corporation CEO didn't say, you know what, team, let's go back to the drawing board. She didn't say, let's get together, figure out what's wrong, make improvements. How about let's make a new product? None of the above. The defendant CEO cleaned house instead. Fired the head of the art department, fired the head of the marketing department, fired the head of finances. If you believe for a second that these firings were justified, that for some reason maybe it's okay to fire the only two people that are in charge of working on this product, there's an easy way to know that the firings were just a front to have easier access to the money. If the problem was the product that marketing worked on, a product that the art department worked on, why fire the chief financial officer too, a person who had nothing to do with the failure of the product. Here's why. Because all that's left is this defendant and her best friend, Avery Ziegler. Two people employed by a company with $9 million in the bank. And what have they done with it? There hasn't been a new product. There hasn't been improvements to the old product. Zero expenses by this company in the last year that you've heard about, except for one sort of expense: salaries. This defendant's still getting paid. This defendant's CEO is still getting paid by her own company. Her best friend is still getting paid by her own company. Kirby Seaborn left this company as a shell to keep money coming into her personal account with a way that she could just say, well, the product failed. Well, the investors, they didn't read the fine print. That's their fault. But that's not how this works, because they made a fake product, and that's real fraud. You know, when we're talking about cryptocurrency and we're talking about mint passes and we're talking about this high-level technology terminology, it's easy. It's easy to forget that real people were involved, that real people were affected, that real people were harmed. But Shea Bartlett took the stand and told you about how she trusted this company, how she believed in this company enough to invest $10,000. She told you that if she had known that this defendant corporation wasn't going to live up to the expectations they created, she would have saved herself the $10,000 and never invested from the get-go. It was a fake who paid real money for a real product they never got to see. It was a fake product, but it was real fraud. So find the defendant liable. Thank you.
Defendant may now present its closing argument to the jury.
Yes, Your Honor. $30,000. That's how much money this plaintiff spent on a concept, on digital art. Most of us, when we have $30,000, that kind of money goes a down payment on a car or a house or to help pay for the first year of a kid's college education. The plaintiff spent that money on a concept. In other words, folks, spent $30,000 on a lottery ticket. It is not College Card's fault that she didn't hit the jackpot. Because the evidence shows that College Card promised her artwork. She got it. College Cards promised her athletes. She got it. And the thing that she's upset about, the fact that she didn't get a video, College Cards did not promise that to her. Members of the jury, this wasn't a fraud. Because College gave the defendant, gave the plaintiff everything they promised. Now, the plaintiff in this case, they've sued College Cards for fraud, but they have a burden. They have to prove to you by a preponderance of the evidence, just more likely than not, that College Cards was involved in a fraud. That College Cards lied to investors in order to get their money. In other words, that College Cards made false misrepresentations and they didn't follow through. The plaintiff didn't meet that burden. They failed to show you that there was an intent to defraud. They failed to show you that there were false representations, that there were lies. And they failed to show you that the plaintiff lost money because of College Cards. They didn't meet their burden, folks, because of three simple facts. One, the plaintiff got the artwork she was promised. Two, the plaintiff got the athletes she was promised. And three, the thing the plaintiff didn't get, the video, she was never promised. So let's take those one at a time. One, she got the artwork she was promised. Ladies and gentlemen, this is the artwork that College Cards promised the plaintiff. This is the artwork that College Cards gave the plaintiff. Your eyes don't deceive you, folks. It's the same thing. The same colors, the same border, the same design, the same little squiggly part at the end, the same lights in the back, the same thing, down to every single detail. This is what she expected. This is what she was told she was going to get. And this is what she got. Fact number two. The plaintiff got the athletes she was promised. One moment, Mr. Trevisani. Plaintiff's counsel got up here and kept telling you that they sold a fake product, that the product wasn't real. Folks, I don't know if any of you are Baylor's fans or if you're a big fan of the Baylor's men's basketball team, but it's a good basketball team. It's one of the best basketball teams in 2021. They won the college championship. This woman and her company was able to secure licensing agreements from that championship basketball team. What does that mean? Essentially, folks, this new company with this young CEO was able to secure licensing agreements from a championship team. That's a real product. That's something most companies aren't able to do. They got a championship team to say, yes, use my name, use my likeness, use it how you want. That's not normal. That's not fake. That's a real product. And that's what the plaintiff got. Davion Mitchell, Jared Butler, Mark Vital. That's what the plaintiff was promised. That's what she saw in the promotional materials. Davion Mitchell, Jared Butler, Mark Vital. That's what she got. Now, she took the stand and said, well, it was the exact same. They told me they were going to give me these very specific athletes, and they gave me the specific athletes. How ridiculous. Members of the jury, that's not ridiculous. That's following through on their promise. That's doing exactly what they said they were going to do. She got the athletes she was promised. Fact number three. The one thing that the plaintiff didn't get, she was never promised. This whole trial, the plaintiff kept saying, I was promised a video. I wanted a video. I was expecting a video. But members of the jury, today you learned that College Cards never told her she was getting a video. Let's look at all the tweets. Tweet after tweet after tweet. You're going to be able to take all of these back to the jury verdict room with you. Read them closely. You will not find the word video. Nowhere in these tweets does College Cards say you're going to get a video. Nowhere in these tweets does College Cards say you're going to get animations in your cards. They don't say you're going to get college players, dribbling down the courts in your cards. Now, opposing counsel says, well, they didn't use the word video, but they posted an actual video. And so that means that they promised an actual video. But look at what College Cards actually said. Take a look at what we envision. A vision. And when the plaintiff took the stand, she said that this wasn't the only time that they indicated to her that this was just a vision. She told you that she went to a Twitch conference hosted by College Cards, and they told her the video was conceptual. Think of it this way, folks. You all might have a family member who makes food that you really like, an uncle, a sister. Imagine that that family member makes the best baby back barbecue ribs in all of Texas. And so after this trial, that family member calls you up and says, I have a vision for dinner tonight. I'm going to try to make you 10 pounds of my famous ribs. But then you go to dinner, and your family member just gives you one rib. Members of the jury, I submit to you that your aunt has not lied to you. She didn't promise you 10 pounds. She promised you a vision. She promised that she was going to try. You might say to yourself, well, I heard 10 pounds. I want my ribs. And that's fair. But members of the jury, the defense is not splitting hairs here. When it comes to fraud cases, the actual words that the companies use is significant. And you might say, I don't care what actual words they use. If I'm going to dinner and I'm looking for ribs, I want my ribs. Well, members of the jury, it's okay to be disappointed in a product. It's okay for the plaintiff to be disappointed that she didn't make the money that she was expecting. But members of the jury, just because someone is disappointed doesn't mean they were defrauded. And the plaintiff says, no, we know that this is fraud. But their witnesses said something different. They called a witness named Casey Lyman. And throughout that cross-examination, I kept asking Mr. Lyman, sir, in July of 2020, you didn't think it was a fraud. In August of 2020, you didn't think it was a fraud. Remember his answer? Remember what he kept saying? Why would I think that? He seemed shocked by the idea that I would even suggest that there was a fraud. Folks, what sense does that make? This is a witness that they're calling at a fraud trial who's saying, I was working for the finances. I was managing the money. I didn't see a fraud. Now, he eventually said, well, now I think it's a fraud. But remember, folks, that's after he got fired. They called another witness, a former FBI agent who told you that she did an investigation into this company to see whether it was a fraud. Remember the results of that investigation? After that investigation, there was a criminal trial. For fraud, the CEO of Kelly Cards was found not guilty. The plaintiff also says, well, we know this is a fraud because she kept all the money for herself. You know, they got the money from the investors and they didn't do anything with it. We know that's not true because their witness said something different. They called Casey Lyman. This was the person running the finances. Casey Lyman said, we spent money on the artwork, $250,000. Casey Lyman said, we spent money on the athletes, $250,000. So folks, if it's really a fraud that Kelly Cards was running, why would they bother spending the money at all? Think about it. They say, this is what we envision. They put out the video. They get $10 million. If this were really a fraud, that's the moment that they're done. That's the moment that she can go to Barbados, go off to another island. It's over. She's got them. She's got the money. She didn't do that. She went and secured licensing agreements. She went and spent $500,000. That's not a scheme. That's not a scam. That's a business. Now, when I'm done talking to you and the plaintiff comes up and finishes speaking to you, the judge is going to give you something called jury instructions. Those instructions are going to have a lot of law on it, and so I want to make sure I walk through it with you now. So first of all, we submit to you that the plaintiff has failed to meet their burden for a number of reasons. First of all, they had to prove to you that College Cards made a material misrepresentation. Well, you heard that their representation was that you'll get artwork. They gave artwork. Their representation was that you'll get athletes. They gave athletes. And so the plaintiff didn't meet this burden. They also had to show that Ms. Seaborn lied intentionally, that she, at the time that the promise was made, it was her intent not to fulfill the promise. Well, we know that's not true because when she said, I have a vision to get the video going, she spent money to get the video going. She said, I have a vision to get the video going. And then she spent $250,000 to fulfill that vision. And so they didn't meet this burden, or excuse me, this element. They also had to show you that the plaintiff suffered injury because of the misrepresentation, that she suffered an injury because she was lied to. Well, this is why I want you to think back to the cross-examination of that FBI agent. I was talking to her about how markets work, and it's intuitive, folks. Sometimes when investors put their money into a market, it's successful. They make a bank, they make their money back, or they make even more money. But sometimes when investors put their money into a market, it doesn't work out. They end up losing money. But the fact that a company fails is not proof that the company was engaged in fraud. This is something called a special interrogatory. It's attached to the verdict form. It asks you a question. Did College Cards LLC commit fraud against Shea Bartlett? Because the plaintiff has failed to show multiple elements of their fraud claim, you can say no. Facts, members of the jury. They're stubborn things. They can't be changed. They can't be avoided. Today, it was undisputed fact that the plaintiff got the design and the artwork that she was promised. Undisputed fact that the plaintiff got the athletes on the artwork that she was promised. An undisputed fact. The College Cards never said that she was going to get the video. We ask that you find College Cards not liable because the plaintiff got everything she was promised. Thank you.
Plaintiff may now present its final closing argument.
Yes, Your Honor. The defense has told you time and time again that Ms. Bartlett got what she was promised. The defendant corporation has told you, well, we told her we were going to give her a sports card and she got a sports card, so we're good. But think about it. It would be like if I told you, well, you bought a car and I gave you a car. Case closed. Even though I showed you a Porsche and gave you a Pinto. It's not just that investors were disappointed in a product. It's that investors were disappointed in a product they paid for. Real investors who had real expectations, who put real money into this defendant's business, all for a fake product. That's fraud. So find the defendant liable. Thank you.
All right, ladies and gentlemen of the jury, you've heard closing arguments from counsel. You've received the court's instructions on the law. The exhibits presented during the trial await your consideration in the jury room. That completes everything in this case except the return of your verdict. The jury is excused to the jury room to deliberate on their verdict. Awaiting the return of the jury's verdict, the court stands in recess. But before I announce the verdict in the case, I'm going to allow the members of the jury to offer any concise comments they think would be beneficial for the litigants going forward.
I'll start on my job, or on my end. Excellent job to all of you. I'll try to keep this very, very brief. I know you're anxious for the results. I think that you have excellent demeanor and engagement, sort of contact with the jury. I thought that was really good. Same for you. I think your manner of speaking is very persuasive without being over the top. The one encouragement that I would give to both of you in the future is to check and see if your jurors can see before you start talking about exhibits, because there were some that I couldn't see really well here, even though it was close, and then I couldn't see really well there because it was an angle. And so I was just sort of distracted and sometimes reading things when I should have been listening to you all. But great job.
I would echo those statements. Given the fact that you guys haven't slept and you've got problems that have changed, I am so impressed with you. I think one of the things that makes a lawyer credible is a stillness and a calmness about their approach. And I think one of the things that's most difficult for women lawyers is finding a voice that's truly theirs and authentic. And those all sound like buzzwords. But for each of you, you've managed to do that. You've managed to find a stillness in your approach. I was so impressed with you from the first moment when you're in my field and you're like, hey, I've got this. Let me just put it back on. I've got this, and there are little bobbles and things that go throughout a trial that tell people this is a lawyer that feels comfortable in her own skin. And I would just commend you both for that. I thought you both had great voice modulation. You both used calmness, stillness, but also quiet spacing. You both know how to have a dramatic moment of quiet in what you're doing. And that's one of the things that I used to work a lot with our young lawyers on, is just feeling comfortable in silence. I want to talk to you about one thing. When you use words like fake and lie, you're taking a little bit away from what you want the jury to do. You want a jury to make those conclusions about big words like that. There are times when people are lying and they are fake, but you almost want to lead everything up to that. And if you want to say that, you could almost leave it as a rhetorical question like, is that what a lie looks like? Is that what a fake feels like? Rather than, that's a fake, you're a liar. Because there's just a different feeling about that. And you want that conclusion to be theirs that they walk away with. Because if they disagree at all, you can be in a bad place. So I think that those are powerful words, great ideas, but I would just think about the phrasing of them. And then for yours, oh gosh, I gotta find my note. Because they said keep it short. I thought you did a brilliant job of distilling and talking really about three main ideas. But when you do that, every word matters. And so you have to make certain in a case about misrepresentation that you're really comfortable about what the misrepresentation is and how you meet that. And so I think that the precision there is really, really important. But you did a great job. And I just commend you both. I can't wait to see your careers. And I love that we were a part of watching all that you'll do. Thank you.
I agree that you're both excellent. This was a pleasure. Hayley, I think your presence and your demeanor is spot on, and it's way past your level of experience right now. It's passe, and you're not supposed to say that anymore, that you own the courtroom, but you do. You are entirely comfortable, and that goes so far. Regina, what I noticed most favorably about you was your ability to react quickly to things that you had just heard a witness say, that there's no way you could, maybe you scripted because you've done this case enough, but it didn't appear scripted. It appeared genuinely. Let me start with what you just said, and I'm going to jump on that right now. And that's incredibly impressive. So I encourage you to stay up with that. Hayley, the one comment I would make, I'm going to hitchhike on what Jen said, in terms of using words. As I understood your closing argument, you said that the burden you had to meet was recklessness when the jury instructions say intent. And Some defense lawyers would have made, I mean, she made a deal of it, she would have made more. You don't want to be reckless and recklessly misstating what you need to prove. So just work on your precision there. Regina, I thought you tried to win too much. You're the defense lawyer. You don't have to negate every element of the case, right? She's got to win them all. You've just got to, and I felt like you kept hammering on some things that were losers, okay? There's some facts in this, I mean, you've got to play the cards you're dealt. There's some facts in this case that are just so obviously plaintiff-oriented. There's just, I mean, even if you're going to challenge them as we go along, by closing argument, you don't need to keep hammering on, pick one or two things and go for it. And I felt like that diluted a little bit at the end because I felt like you went for too much. You guys were both really good.
Really good.
All right, I'm going to exercise a rare quality these days called judicial restraint. I'm going to tell you what the results are. Unlike federal court, this was not a unanimous verdict. This was a 2-1 verdict. But like any court, somebody wins, somebody comes in second. In this case, having heard from excellent advocates, the jury's verdict is that the winner is Hayley Kairab from the University of Georgia. With that, I will recognize Dean Tobin.
Thank you, Chief. Thank you for being here today and presiding in our trial. Your ongoing, forever there faithfulness to Baylor law. So deeply appreciate it, my friend. Wow, what advocacy. I gathered in a huddle with all 4 advocates in the break here, and I told them that they had really made themselves proud, and you have made the profession proud. We all belong to a profession, and the profession's ideals have to be upheld always, and you are exemplars. Thank you so much. Thank you to MG&M for the sponsorship and underwriting of the competition. This has been a remarkable opportunity for all of us to get to know one another and to talk about the future. And we so appreciate your being here and actually being on site to the very end. That means a lot to us. Thank you so much to all of the MG&M partners and colleagues at the firm. Deeply appreciate it. And now I'll turn it over to Robert Little, the king of all things Top Gun.
I have nothing. Thank you all very much. Congratulations, Hayley. Congratulations, both advocates.